Good evening. Good evening. Sorry, we're running about 15 minutes late. Sorry. शुरू करें? ठीक. Preamble, fundamental rights, directive principles and fundamental duties. Topic number 3, fundamental rights. Subtopic number 10, writs. Now, before we begin, there are some important conditions that have to be understood. One, we were done, we did Article 12, we did Article 13, and then we did Articles 14 to 30. Yes? Article 12 gave us the definition of state. Article 13 told us that no law can violate Part 3. 14 to 30 effectively gave us substantive fundamental rights. Now, 31 is a set of terms and conditions. Now, this Article 31 should be better understood in the context of the doctrine of basic structure. And then we have Article 32. Now, when we do writs under Article 32, we cover what is called the writ jurisdiction of both the Supreme Court and the High Court. We don't do it separately, right? Now, to begin with, we must understand its relevance for the exam. In the prelims in the last 10 years, there have been 2 questions on writs. One out of the 2 questions is factually incorrect by the UPSC. Yes. According to UPSC's official answer key, a writ of mandamus cannot be issued against a public sector undertaking, which is factually incorrect. There is no way that is to be true, and that is an error on the part of UPSC. You will have to overlook that error. We will still hold our ground to be true. See, when the UPSC gives different answers to abstract questions like right to vote versus right to be elected versus right to contest elections or the meaning of liberty, you can give UPSC that benefit of doubt, undoubtedly. But for a settled law that a writ of mandamus can be issued to a public sector undertaking, because a public sector undertaking is state, is factually uncompromised. But last year, this was declared as wrong, to the absolute shock of everyone, but wrong. Clear? In several petitions in the Supreme Court also, this has been made aware, and the Supreme Court judges have also been a little scared. How dare you ask a question like this? Especially if you're aware of the CSAT issue that is generally going on, where people have been asking for an additional attempt for CSAT. They have actually quoted this question, stating this question to be a factually incorrect question. So, as far as the prelims is concerned, the frequency is less, but in the last 5 years, there have been questions on writs, which means this is a new trend. This means the possibility of a question being asked on writ is very, very likely. So, we have to prepare the absolute basics of it. In the prelims, what do we need to know about writs? What are they? Against who can they be issued? When they can be issued? And when they can't be issued? Answers to these basic questions. What are they? Against who can they be issued? When can they be issued? And when can't they be issued? The answer to these basic 4 questions is enough for the prelims. Now, for the mains, absolutely 0 questions on writ. For a very simple reason, because writ jurisdiction does not necessarily have an analysis behind it, does not necessarily have a complex legal concept behind it. Whatever Supreme Court judgments have been there on writs have been on the procedure of writs, and therefore that is not in your syllabus. So, do we need to prepare analytically writs for the mains exam? No. Then the second question is, do we need to prepare writ jurisdictions comparatively for the mains exam? The answer again is a no, because for any question to come from a comparative constitutional perspective, the issue should be common to us and the other country. And the way we have designed our writ jurisdiction is fairly unique to us. So therefore, writs as a topic singularly does not have to be prepared for the mains. Having said that, writs like Article 13 Clause 2 is instrumental in facilitating judicial review. If Article 13 Clause 2 says, and this is where you start with the context of it, when we look at the context of writs, writs in one single line is nothing but a court order enforcing a right. Enforcing a right. Now, if you remember carefully, we understand that there are 2 kinds of rights. We've got fundamental rights and we've got constitutional rights / statutory rights. Though constitutional rights and statutory rights are different kind of rights, wherein constitutional rights are within the constitution but outside part 3, and statutory rights are under any other law. But when we look at enforcement, they are equal. The way you enforce a constitutional right versus the way you enforce a legal right or a statutory right is the same. So for enforcement purposes, they are effectively the same. Otherwise, you've got fundamental rights, constitutional rights and statutory rights. They are different. They are definitely different. Fundamental rights are those rights specifically enumerated in part 3. Constitutional rights are those rights which are in the constitution but outside part 3, like right to property, right? Like right to vote. Statutory rights or legal rights are those rights specifically guaranteed to you through any other law apart from the constitution. So consumer rights are statutory rights. Yes, tenancy rights are statutory rights. These rights are given to you, for example, by the Consumer Protection Act. These rights are given to you by the local land laws. They are not specifically rights specifically in the constitution. Do we understand this? Yes. They're also different on multiple fronts. We've discussed this before. You require, say, special majority to change constitutional rights and fundamental rights. You require a simple majority to change statutory rights. We've done all of those things. No problem. Do you recall it now? It's one of the first things that we've done in theme 3. You've done a comparative review, right? But in terms of enforcement, if your right has been violated, and if your fundamental right has been violated, you can directly go to the Supreme Court. You can go to the High Court also. but you can directly go to the Supreme Court. If your constitutional right or your legal right is violated, in both of these cases, you can directly only go to the High Court, and only then when you have no other remedy available. For example, your consumer right is a legal right. If your consumer right has been violated, you cannot directly show up to the High Court, because the Consumer Protection Act gives you an alternate legal remedy. That alternate legal remedy are your consumer courts, your consumer redressal forums. So, whether it is a constitutional right or a statutory right, their methods of enforcement are the same. What we have created as a special method of enforcement is fundamental rights. This also teaches you something more important. That means a right is as good as it being enforced. A right is as good as it is being enforced. So does that mean that constitutional rights and statutory rights under the eyes of the law are similarly placed rights? Yes. Because what is the difference between a fundamental right and a constitutional right? You cannot make a law violating a fundamental right. There is no such thing said about a constitutional right. Yes, the same applies to a statutory right. The Constitution is the supreme law of the land, great. But where is it written that no law can violate anything in the Constitution? It's not written anywhere. What is written is Article 13, Clause 2, that you cannot make a law violating fundamental rights. That's all that is written. You cannot make a law violating fundamental rights. So in that sense, whether the Constitution is supreme or not, fundamental rights are certainly supreme. Are we clear on this? So if no law can be made to violate a fundamental right, a law can be made to restrict or violate a constitutional right or a statutory right? Yes. In fact, sometimes statutory rights can violate constitutional rights. Property is a classic example. Right to property is a constitutional right. It is also a legal right under several laws. For example, the Transfer of Property Act. For example, a proposed land acquisition law. The government can compulsorily acquire your property for developmental reasons, and you would be paid a fair price for it, but you still have your property to be taken away by the government. So effectively what we are referring to here is that in the rights ecosystem, you have fundamental rights on one hand and you have all other rights on the other. That's the basic understanding, that fundamental rights on one hand and all other rights on the other. That's the fundamental primary understanding. Do we get it? Now comes the larger question. What we are effectively saying is that a writ is nothing but an order of the court uplifting a right. Yes, a writ is nothing but an order of the court, a judgment of the court, a direction of the court upholding a right. Now, what are the circumstances in which a right could have been violated? How is a person's right violated? Any right. State action. Now, a person's right is violated through an action of the state. Now, what are the components of the state? The legislature, the executive, and the judiciary. Now, judiciary is going to become a little bit of a gray area, a little bit of a red area. Why judiciary violating your rights is not maintainable is the same reason why the judicial functions of the judiciary are not considered state under 12. We've done this. The reason why the judicial functions of the higher judiciary is not state is the same reason why writs cannot be issued to higher courts. The reason is the same. Otherwise, they will not be able to review action. Otherwise, the constitution will not evolve. Otherwise, basic structure is going to get compromised because judicial review is going to get compromised. So the reasons are the same. But if a state action violates a right, a state action could be a legislative action and an executive action. What is a legislative action? It could be a law. An executive action could be an order. Yes. Any law or any order issued by the state, implemented by the state, passed by the state can violate your rights. Yes. So therefore, what is going to happen is that generally it's going to be a law or an order issued by whoever, does not matter, versus the rights. Yes. And now this is the job of the judiciary, to decide one between the two. What is the judiciary going to do? Either the judiciary is going to validate or invalidate the law or the order. Yes. If it is validating, it can give an interpretation of some kind. Yes. And third, in case there is a gap in the law, then the judiciary can fill that gap by giving some additional discourse. This is called judicial legislation that we have spoken about, like the Vishakha case. Yes. Article 21 to include privacy is a matter of interpretation. Yes. Declaring section 66A to be violative of Article 19 is invalidating section 66A of the IT Act, Shreya Singhal case. And issuing guidelines preventing sexual harassment against women at the workplace are Vishakha guidelines. This is what the court does. Yes. Now, put it all together. Put it all together. A writ is to correct a right action, right? If it came down to a law, you've done these things. But what about an order? Yes. Somebody would have authorized something. Yes. What if you need to stop the implementation of the law immediately? What if you need to put pause on saying, don't implement this law? Like we have done for sedition. The Supreme Court has stayed sedition. The earlier criminal code, the Supreme Court has stayed section 124A of the Indian Penal Code, that no fresh FIRs will be filed on the grounds of sedition. Sometimes you will have to overturn an order. Sometimes you will have to tell them what to do and what not to do. All of this is only possible because of writs. So that is why writs have a very important role to play in judicial review. Do we understand this? This is the ecosystem. And the more liberal the courts are, this judicial review can sometimes enter problematic areas of judicial activism or judicial adventurism. This can sometimes be catalyzed by public interest litigations. This can sometimes, on the other side, very rarely, also be catalyzed by suo motu cases. तो ये पूरा इकोसिस्टम ऐसे बनता है. Are we clear on this? What we are effectively referring to is the grand concept of judicial review. The reason you can do judicial review in the first place is because of Article 13 Clause 2. But this is only for fundamental rights. This is only for fundamental rights. So, to enforce rights, where you have 13(2) on the other side, you have Article 32 for fundamental rights. Yes or no? No law can violate a fundamental right. Here, law means everything. Yes or no? Law means everything. What does law here not include? Constitutional amendments under 368. And we've discussed this in class. Emergency proclamations. Otherwise, an act is a law, an order of the government is a law, everything else is law. Right? No law can violate a fundamental right. If a law, and by law here we mean law and order, violates a fundamental right, Article 32 gives you the power to go to the Supreme Court directly. It also gives you the power to go to the High Court if you want to. Right? On top of this, judicial review means what? Judicial review means the review of state action. The review of state action. Now, every state action does not necessarily have to be around fundamental rights. A state action can be on other rights. A state action can be generally. A state action could be in any other nature. Yes. But if a state action is violating any other right other than a fundamental right, then you have the powers of 226, where you can approach the High Court directly. Do we understand this? Yes. And this process can be catalyzed with, can be, put a little bit of ghee in fire, could be sped up, could be abused with concepts of PIL and concepts of suo motu. This is the ecosystem. Writ jurisdiction is effectively to maintain what is called judicial review. That is why you have writ jurisdiction. Are we clear? And judicial review, as we know, has time and again declared by the Supreme Court as one of the elements of basic structure. As one of the elements of basic structure. So writ jurisdiction is an instrument to uphold judicial review. What will the court review? What will the court do? One of the things that the courts can do is issue writs. So that is the correlation. Understood this? And an abuse of this could lead to judicial activism / adventurism. We'll come to that later. PILs are necessarily good, necessarily bad, all of those things. Because it is through this power of a writ, the Supreme Court has made some extraordinary judgments, and it has also made some extraordinarily questionable judgments. Both of those things have happened. For instance, when the Supreme Court issued a writ in COVID, directing the management of prisons in India to release several under trial prisoners, that was exercise of writ jurisdiction. Why are you keeping people closed in a jail? Half of them have not been even given, have not been even declared guilty. They're going to only be a part of a COVID hotspot. You're unnecessarily subjecting their lives. It is through this that they have ordered the governments that do not file any fresh FIRs on sedition, on section 66A. It is through this that they have directed the government that, you know what, we are declaring triple talaq as unconstitutional. We are directing you to make a law making it criminal. Right? Eventually writ. When the UPSC stops your candidature and we have to go to the court, what do we ask for? A writ. Please direct the UPSC to allow these children to sit in the exam, to appear for the interview, to consider their status. Writ is nothing but a legal remedy, a legal recourse. And do we understand this? Yes. And sometimes certain usages of the writs have been fairly questionable. For example, it is through a writ that the Supreme Court cancelled coal allocation after the coal scam. Do you remember the coal scam? Yes. So about 10 years ago, most of you would not. Before 2014, a huge scam had broken out, where the CAG had basically released a report saying that when we were allocating mining licenses, we allocated mining licenses on a preferential basis. We did not conduct an auction. We gave it preferentially to a few companies. As a result, the rates at which we gave those mining licenses those rates were fairly low and were given to people who did not deserve it, who did not have the expertise for it, who did not have the years of experience for it, who did not have the technical know-how for it, was generally given to companies which were politically connected. Okay? So the CAG wrote this down in their report. And this is just a year before elections in 2014. So this became a national issue. And what the CAG wrote in their report was that this is a notional loss. A notional loss means, had you auctioned your coal mines, you would have made 1.7 lakh crores. Had you auctioned it. Because you did not auction it, you lost 1.7 crores. It's not as if you actually lost 1.7 crores. You lost the opportunity to make 1.7 lakh crores. This is called a notional loss. The Supreme Court issued a writ cancelling all licenses. Yes. Similarly, we are in the era of 5G. So there was a time when there was 2G, and the speed at which we have gone generational upgrades is unprecedented. In 10 years from, I think, 2G, we are in 5G. The pace of technology is unprecedented. It's scary, but it is unprecedented. So what is a 2G? A 2G is nothing but a spectrum of telecommunication. These spectrums are owned by the government. These are government properties. These spectrums are allocated to companies who can then use these spectrums to run telecommunication companies like Airtel, Jio, Vodafone, Idea, so on and so forth. They will use these spectrums. These spectrums are nothing but waves, which will allow for transmission of voice and data. Now the same principle applied here also. Everybody doesn't get a 2G license. Only those who have the expertise, the know-how, the experience, the funds, because telecom investments are huge, should be given 2G licenses. You may remember a company called Aircel, which is now vanished. Aircel was one of the few companies who got a 2G license. And then it was an issue. How did you get it? Why were 2G licenses also not auctioned? There is a clear-cut misappropriation of funds. There is a clear-cut politician, bureaucracy, corporate nexus that is operating in the inner corridors of Latvians. That is exactly what was said in 2030. Okay? The Supreme Court, with one writ, cancelled all 2G licenses. Straightforward. Now my point is, can the Supreme Court do this? Yes. Should they? I don't know. I honestly don't know. The decision to preferentially allot licenses or the decision to preferentially allot coal mines is a policy decision of the government. The Supreme Court cancelling a policy decision is a violation of separation of powers, which is why when on one hand you have judicial review as basic structure, on the other hand you also have separation of powers, which is also basic structure. I understand with separation of powers you need checks and balances, but where does the line end? How much is okay? How much is not? Are we clear on this? Think about it. Take the most recent example. Do you remember the Supreme Court judgment on decriminalization of homosexuality? Very clear cut. We hereby declare section 377 should not include homosexuality. The new criminal law does not even have section 377 anymore. It has no reference to anything to do with unnatural sex anymore. It doesn't deal with that anymore at all. No problem. Now, compare that judgment to the more recent judgment on the Supreme Court invalidating same-sex marriages, saying we do not allow or we do not approve or we do not declare that same-sex marriages should be legal. Should they be legal, let the parliament make a law. Right? Should they be legal, let the parliament make a law. Right? Very clear cut. So, writs, judicial review, basic structure, judicial activism, separation of powers, checks and balances, they're all in the same ecosystem. This is why when you have topics like basic structure, judicial review, separation of powers, why will the mains exam ask you to analyze the weapons? You understand? Fundamental rights are the bullets. The writs are the weapons. They are the guns in which you load these bullets and fire. Yes? You never shoot the messenger. Writs are the messengers. They are just there because fundamental rights are there. And if writs did not exist, fundamental rights would have no meaning, would have had no value. Because if you remember carefully, the third pillar of rule of law is predominance of legal spirit. And one of the ingredients of the predominance of legal spirit is every right must have a remedy. Pause करें? Can you guys hear me anyway? है ना? There was something on Lohri yesterday, day before. In my society, they were celebrating Lohri, and they were playing a song. क्या था? दुनिया मिटा दूंगा. So out of context for Lohri. क्या वॉइस ठीक है सर? होने दो, कोई नहीं, चिल्ला लेंगे. Does it make us anti-secular? Are we anti-Hindu by doing this? No, na? Okay. Because I've done far more anti-Hindu things than just. Okay. All right. So therefore, my point being, when you have these grand questions of judicial review, separation of powers, all of these things, right? All of these things. Why would they ask you a random mains question comparing writ jurisdictions? Why would you do this? Why would you be asked a random question on writ jurisdictions? Understood? So this is your ecosystem. Now we will study writs. Before we get into the technicalities of writs, thank God. Do you want a holiday on 22nd? Yeah, because we'll have to see how law and order is. If there is a generally mandated holiday, then, but otherwise we'll see. So on 22nd, anyways, writs. Now we look at comparing courts with respect to writs. Now comes the larger question. You can directly go to the Supreme Court, if your fundamental rights are violated. You can directly go to the High Court if your fundamental rights or any other right, which includes your legal rights and your constitutional rights, are violated. We're okay with this? Yes. So what does this mean? Does this mean that the high courts have more powers than the Supreme Court? Yes. But what kind? You must understand this. This does not mean that the high courts have more powers. It simply means the high courts have a wider jurisdiction. There's a key technical difference. A wider jurisdiction, which means the High Court can directly hear cases of fundamental rights and legal rights. The Supreme Court can directly only hear cases of fundamental rights. This means the High Court can directly hear a larger number of rights cases. This does not mean that there is any difference between their powers. Both of them have the exact same powers to issue the exact same writs. you have to appreciate and you have to understand the nuance in this statement. When I'm saying that the Supreme Court and the High Courts have the exact same powers to issue exactly the same type of writs, what does that signify? What is it supposed to mean? What is it supposed to tell you? Tell me. If I am saying the Supreme Court and the High Court can issue exactly the same kind of writs, that means the Supreme Court and the High Court have equal writ powers. Can I go talk to them? Why? I can request them. नहीं, आप लोग नहीं. मैं एक sec. Let me go talk. If I don't come back, you know. Sir, एक minute pause कर. What does this signify? That the Supreme Court and the High Court, but the Supreme Court is a higher organ, a superior organ, and the High Court, which is a regional organ, have the exact same powers. What does this signify? That they have the same powers? How is that justified? Agreed, you're right. That cases from the High Court on appeal will go to the Supreme Court. Agreed. But in that very instance, at that very moment, the Supreme Court and the High Court have the exact same powers to do exactly the same thing on exactly the same issue. For example, take the case of decriminalization of constitutionality. 377 of the previous Indian Penal Code, yes, declared homosexuality to be unconstitutional. The first time a case like this was filed at the Delhi High Court. Yes or no? The Delhi High Court declared it as unconstitutional. Then you went to the Supreme Court. The Delhi High Court case was the Nas Foundation case. The Delhi High Court first declared it as unconstitutional. So in the region of Delhi, homosexuality was legal. Then it went on appeal to the Supreme Court. The Supreme Court reverted it back to the Delhi High Court. Then the Delhi High Court reversed its earlier decision and made it constitutional again, and therefore make it criminal again. But my point is that challenge to homosexuality could be undertaken at the Delhi High Court and at the Supreme Court. Both had equally the same powers to declare Section 377 as unconstitutional, doing exactly the same thing. The difference being the Delhi High Court judgment will only be for the region of Delhi, and the Supreme Court judgment would be for the entire territory of India. Correct? Yes? Understood. So therefore my question is, simple question is, if both courts have the same powers, they are hierarchically different. How is this possible? The only difference is the area of operation. Yes? Which is why, if you ever look at the eligibility conditions to becoming a Supreme Court or a High Court judge, your number of years as an advocate is the same. Because if you take center state powers away from the Supreme Court is nothing but a national high court. If I take center state adjudication powers away from the Supreme Court is nothing but a national high court. And if I give center state dispute powers to the High Court is nothing but a regional Supreme Court. Which is why the eligibility criteria for Supreme Court and High Court judges are more or less the same. Because of this, they're performing substantive functions of judicial review. Do we understand? Yes? No. So once the Nath Foundation case got over, then you had Navtej Singh Johar. Let me just simplify it. Okay. Step 1, Nath Foundation case at Delhi High Court. Delhi High Court declared criminalization as unconstitutional. It legalized homosexuality. The government appealed in the Supreme Court. The Supreme Court directed the matter to Delhi High Court again. So a higher bench in the Delhi High Court then reversed its own judgment. Only Delhi. Agreed. But the judgment that has been given by the highest judicial authority of the state. If you had allowed this Delhi High Court judgment to be applicable throughout the territory of India, what would effectively happen is a High Court judgment is applicable to the other High Court. Could be applicable to the rest of the country. If that is the case, then what is the territorial hierarchy between the Supreme Court and the High Court? Are we clear on this? समझ में आया? ठीक है. So what you need to functionally understand is that though, and this is a very important piece of interpretation, don't do the mistake of undermining the powers of the High Court. The High Court of India, when it comes to citizens, when it comes to individual rights, is just as powerful as the Supreme Court. In fact, has a wider playground to play with. If your consumer right has been violated and you did not have a consumer court, then you would effectively be going to the High Court. You could not go to the Supreme Court. You didn't have the powers to go to the Supreme Court. That's the essence. That's the understanding. Are we clear on this? That's the basic concept. Yeah. If ADR is statutorily mandated. If ADR is not statutorily mandated, it is not included. So very good question. What if an alternate remedy is in the form of arbitration, mediation, reconciliation, let us say in the form of a Lok Adalat? If it is mandated by law, then yes. If not mandated by law, then no. For instance, in divorce cases, it is almost a set procedure by most high courts that before you come to us for divorce, finish a round of reconciliation at your level. Then you come to us. That is mandated ADR. Okay? Understood? Yes? ठीक है. Done. Now, when we say Article 2, 226, allows for any other purpose. What does this mean? Article 226 says you can issue writs for any other purpose. This any other purpose means that you can issue it for legal rights and constitutional rights. That is how we know Article 226 is for legal rights and constitutional rights. Because Article 226 includes the words for any other purpose, right? The second interesting observation here is, technically, these are powers of the court, and powers of the court in our constitution are very categorically given in a certain chapter. Yes, you have union judiciary and state judiciary. In union and state judiciary, you have the powers of the Supreme Court and the powers of the High Court very clearly. Yes or no? Then why do you write this separately? This is technically the power of the court. Article 32 is not written in the powers of the court. Article 32, which gives the Supreme Court the power to enforce fundamental rights, the power to protect fundamental rights, the power to uplift fundamental rights, is given in part 3. Not in part 5, not in part 6, but part 3. Why? Yes, it's an extraordinary power, but why? Because nothing in no law can be made to violate part 3. Part 3 includes Article 32. If this was not in part 3, if it was in the section on powers of the Supreme Court, you could reduce it. You could dilute the writ jurisdiction. So a unique feature is that our fundamental rights have been placed in a manner, and the enforcement procedure is also within the fundamental rights. You have sort of divided and bifurcated Supreme Court powers. Supreme Court has original powers to listen to center-state disputes. Supreme Court has powers to listen to civil cases, criminal cases, appeal cases, PILs, precedent advisory. Everything is written in one place. But not 32. Not writ. Writ is exclusively mentioned under part 3. Right? And ever since basic structure is judicial review, you cannot reduce the powers of the High Court under 226 either. Ever since judicial review is basic structure, you cannot reduce the powers of the High Court under 226. You cannot eliminate it. You can create alternate legal remedies like tribunals, alternate dispute resolutions. Yes, but you cannot curtail the ultimate powers of the Supreme Court or the High Court. That is the essence of it. Clear? Now, Article 32 itself is not a fundamental right. Very important. The right to constitutional remedies in itself is not a fundamental right. It is the way to enforce a fundamental right, to uphold a fundamental right. Which means the applicability of Article 32 can sometimes be restricted. For example, in our emergency provisions from 352 to 360, there are constitutional provisions that can temporarily suspend your ability to come to the Supreme Court. I understand right to life and liberty can never be suspended. I understand your right to life and personal liberty can never be touched, can never be questioned. can never be bothered. Completely understood. Yes, absolutely. But if during an emergency your Article 21 has been violated, if during an emergency your Article 21 has been violated, in that case, during that emergency, you cannot come to the Supreme Court. Once the emergency is over, then you come, no problem. We will discuss what happened to you during the emergency also. But in the period of that emergency, you cannot approach the Supreme Court. Do we understand this? Yes. Now, because of this understanding, we know that 226 is wider than Article 32. Clear? Okay. Now, this too hard, too loud? किसको 226 को 226 को इसलिए नहीं डाला बिकॉज आपने फंडामेंटल राइट्स के लिए तो स्पेशल प्रोसीजर दे दिया. अगर 226 को डाल देते, then for legal rights also you could directly move to the Supreme Court. या 226 में 226 is not just for fundamental rights, it's also for legal rights. 32 is only for fundamental rights. It's only for fundamental rights. Sorry? My fault. फिर से बोलिए. Can I remove Article 226 through a constitutional amendment? Yes, if judicial review was not declared basic structure by the Supreme Court. There's Sampath Kumar's case, there are several other cases. ठीक है? All right. एक काम करते, let's stop here because they don't have a function tomorrow. We'll do a longer class tomorrow if that's okay with you, because I want to finish writs in one go, and my target is to finish basic structure and everything by Wednesday itself, so that we can start with the executive on Thursday. So we'll start tomorrow, we'll finish writs. I asked them also that is it tomorrow also, they said no, we have 4 to 7 PM is our Karyakram. Good afternoon everyone. Good afternoon. Theme 3, Preamble, Fundamental Rights, Directive Principles and Fundamental Duties. Topic 3, Fundamental Rights. Topic 10, Writs 2. So yesterday we understood the constitutional justification for writs. We understood that writs are an instrument of what is called judicial review. We understood that while the Supreme Court and the High Court have the powers to issue exactly the same kind of writs, it's not as if the Supreme Court can issue another different kind of writ, nor is it that the High Courts have more types of writs to issue. What basically happens is the High Court can issue writs on more than just fundamental rights. We also understood the peculiar positioning of writ jurisdiction in Article 32. We figured out it is not written in the other part of the Constitution which refers to other Supreme Court jurisdictional powers. We'd also figured out that writs is dominantly a prelims topic and not a mains topic. But in mains questions on judicial review, you will give a reference as far as Article 32 and 226 is concerned. We figured out yesterday that writs is effectively a court action against a right violation. A court action against a right violation. Now, this statement in itself breaks down into smaller questions. The first question becomes, what type of court action? The second question becomes, against who? Right? The second question becomes, against who? And third, what is the outcome of it? What kind of right are we looking at? We figured out we have same writs for all kind of rights, whether they're fundamental rights, constitutional rights, or legal rights. Based on the difference between what and who is the differentiation between writs, right? So let's start. The Constitution effectively tells us there are 5 kinds of writs. First, habeas corpus. Second, mandamus. The third, prohibition. Fourth, certiorari. And fifth, Quo Warranto. Now, if these are the kind of writs, against who and what is the outcome, what is the purpose of it, what are the contents of it? Let's first understand the writ of habeas corpus. In one line, the purpose or the outcome of habeas corpus is, in one simple line, illegal detention. Illegal detention. Now, take a quick understanding what all fundamental rights violate illegal detention. Let's start from a descending order. The most direct right to the most umbrella right. Okay? So what is the most direct right? 22. Very good. By extension 20 also, let us say. Apart from this, yes, when you are detaining someone, and that too illegally, the 2 sets of rights that you would definitely be violating are 19 and 21. And the second 19 and 21 are violated, Menka Gandhi kicks in, and automatically 14 becomes a question mark, right? Now, 22 we are very clear, it is about protections against arrest and detention. 20 we know are general principles of criminal justice, retrospective, double jeopardy, self-incrimination. 21 we know life and personal liberty. So the second you are illegally detained, basically your personal liberty has been compromised, which then brings me to the larger question, what about Article 19? What is it about Article 19, and we've covered this in class, does an illegal detention violate? (19.5) 19.1a, B, C, D, E and G. A is freedom of speech and expression. B is peaceful assembly without arms. C is the freedom to form union and associations. Yes. D is movement, E is to reside and settle, and then F is cancelled out because of property. Then what you have is G, which is free profession, occupation, trade and business, POTB. So what is illegal detention specifically violating? It is violating 19(1)D to begin with. You can argue ABC, you can also argue G, you can also argue E, but primarily what it is violating is Article 19(1)G, and that becomes important. Are we clear on this? Yes? Now, why would you have this right in the first place? Why would you have this provision in the first place? Why would you specifically have a writ on habeas corpus in the Constitution? When you have a dedicated fundamental right which guarantees protection against arrest and detention, Mandamus would have covered habeas corpus in a certain way. But why do you specifically refer to habeas corpus? This is a colonial context. We have seen a history of British laws being applied to India wherein people were illegally detained. Whether it is the Ilbert Bill, the Vernacular Press Act, and so many different kind of British legislations. So as a context of this, even section 144A sedition, 124A sedition, the British have been rather infamous of illegally detaining Indians without giving them a due process under law, and therefore questioning the entire criminal justice ecosystem. As a consequence of this, the makers of the Constitution wanted to specifically insert the writ of habeas corpus. Fair enough. Now, what does the writ of habeas corpus effectively give you? Does it give you release from illegal detention? No. What does it specifically give you? In one simple line, when the court wants a specific person who has been detained to be produced before the court so that the court can inquire about the detention or the arrest. This is an inquiry writ. Just because the court has issued a writ of habeas corpus does not mean it is proven that you have been illegally detained. It is an inquiry writ. The court has basically directed you to ensure that whoever you have illegally detained or allegedly illegally detained to be produced before the court. A writ of habeas corpus is not a guarantee of conviction of illegal detention. It does not prove that illegal detention has necessarily happened. Understood? And therefore, if the court, now how does this work? You go to a court, Supreme Court or High Court, you have to prima facie prove that there is no law under which a specific person who has been detained by a specific person is permitted. So on the face of it, in the law we use a term called prima facie. On the face of it, you are therefore illegally detaining a person. So that is the essence of what is called habeas corpus, a Latin term which means to produce before a court. Understood? Now, if the writ of habeas corpus has been issued on a specific date, suppose today, then the writ can also ask for the person to be produced the same day itself. same day, same time, immediately with effect. This is, you can bypass ordinary procedures. If the writ has been issued of habeas corpus, no matter where the person is, if the writ has asked you, if habeas corpus has been issued for you to be produced today, you have to be produced today. Doesn't matter. Are we clear? So ordinary rules of civil procedure, criminal procedure, which now have been changed into a different criminal law, they can be bypassed for the writ of habeas corpus, right? Now, think about it logically. If somebody has been illegally detained, then the person is already under stress. The person is already under a lot of trauma. For you to subject them to the fees of the court, the charges of the court, that would not be justified. So what happens in habeas corpus is, you do not have to pay any court fees for habeas corpus petitions. If you have filed a petition praying for habeas corpus, you do not have to pay even a single rupee to the court for court fees. Otherwise, you have to pay a nominal amount to the court to get your case registered in the court. With habeas corpus, court fees is not applicable. You don't have to pay for it. Are we clear on this? Yes? Understood? So therefore, any of these criminal proceedings, now what is going to happen is, once the writ of illegal detention, the writ against illegal detention, habeas corpus has been issued, it would be largely because of a criminal law. You anyways cannot be detained under civil law. You have to be detained under criminal law. If you have been detained under criminal law and a writ of habeas corpus has been issued to you, not only are you exempted from the writ court fees, but any criminal proceedings that happen because of it, you do not have to pay any court fees, right? Now, we've got some options with respect to who? The legislature, the executive, the judiciary, and private persons, right? The legislature, the executive, the judiciary, and private persons. So now the question is, if the writ is against illegal detention, that means somebody would have ordered for illegal detention. Yes. The legislature does not order anything. A law may provide for it. The law may be questionable. You can question the constitutionality of the law, but the law doesn't order anything. The executive who's implementing the law orders it. CRPC allows for curfew, but is CRPC passing the order for curfew? No. The collector is using CRPC powers under 144, which has now changed, to impose curfew. So the person executing the warrant or the order for detention can never be the legislature. It's not possible. The law would be questionable, no doubt. You will never have a writ of habeas corpus against a law. Do we understand this? But can there be a writ of habeas corpus against a legislature? Think about it carefully. It is impossible because law is intangible. Somebody has to take some action. There has to be some order or some act by anyone which has caused illegal detention. Yes. So can the parliament or the state legislature illegally detain you? No, nobody can illegally detain you. But do they have the capacity to do this? Now think again. Do the legislatures in any form, capacity, in any manner, have any powers to take criminal action against you? Really? Breach of privilege? Under breach of privilege, civil action can be taken, criminal action can be taken, and breach of privilege is across multiple laws. Some breach of privilege is in the rules of procedure. Some things governing breach of privilege are in criminal laws. Some things are in civil procedure. There are multiple laws which govern privileges in India, and there are parliamentary conventions also. Most of these parliamentary conventions are modeled on the British parliamentary system, that we know. But my question is, tomorrow, if I write a scathing article and a scathing editorial beriding and deriding the Lok Sabha, and maybe specifically targeted to the Speaker of the Lok Sabha, have I committed breach of privilege? Yes or no? Yes, I have. A breach of privilege can be by anyone, a member of the parliament or any person out of it. So tomorrow, if I write an editorial in the newspaper criticizing the Speaker of the Lok Sabha for not being impartial, for being a little allied towards a certain section, without basis, without enough data, without anything, just an accusation of an article, have I committed the breach of privilege of the Lok Sabha? Yes. Now, if I have committed breach of privilege, what powers does the Lok Sabha have to punish me for the breach of privilege? They will immediately refer it to the ethics committee, and there can be civil proceedings, there can be criminal proceedings. Yes, they can sentence me to jail, they can ask me to pay a fine, they can ask me to render an apology, they can ask me to pay compensation. It could be all of those things. A breach of privilege is when the parliament also acts like a quasi-judicial body, which means if the parliament has the power, if the legislature has the power to criminally punish me, they would also have the power to detain me. And if they have the power to detain me, then they can also illegally detain me. Yes. So a writ of habeas corpus cannot be issued against law, but against legislature. Yes. Understood? Yes. So technically, can a writ of habeas corpus be issued against the legislature? Yes. Any legislature. Because as far as privileges are concerned, both MPs and MLAs have the exact same set of privileges. The exact same set. Not a word here, not a word there. Yes or no? Yes. Good. Now, obviously, can a writ of habeas corpus be issued against the executive? Yes, of course. Because it is the executive which has the powers to implement criminal law. My point is, illegal detention can only happen because of criminal law. So whoever has the powers to enforce criminal law should have the powers to enforce detention, and whoever has the powers to enforce detention, that means you have also the capacity to enforce illegal detention. Yes or no? Correct. Good. Now comes the judiciary. Now the judiciary cannot be looked as a collective, because the judiciary is going to have higher judiciary and lower judiciary. The difference between higher judiciary and lower judiciary is, what is the difference? Higher judiciary is Supreme Court and High Court. Lower judiciary is District Court and below. So what is the fundamental difference between the Supreme Court and the High Court? Between the higher judiciary and the lower judiciary? Issuing writs, yes. Higher judiciary can issue writs, lower judiciary cannot issue writs. And writs are an instrument of judicial review, which means the powers of judicial review are with higher courts, not with lower courts, right? Which means it is only the higher courts which have the powers to pronounce on the constitutionality of a law. Whether a law is constitutionally valid or not, only the Supreme Court and the High Courts of the country can decide. The lower courts cannot, right? Now apply habeas corpus to this. If the High Court has upheld illegal detention, then that High Court order has effectively facilitated illegal detention. Yes? So technically, I can issue a writ of habeas corpus against the High Court. The problem is, this will make the job of the High Court counterproductive. The reason writs cannot be issued by higher courts to higher courts is the same reason why higher judiciary is not state. Higher judiciary is not state because then you can never pronounce on constitutionality of issues. You cannot perform judicial review, because even if you say X is not a violation of fundamental right, people are going to challenge that order, saying that High Court has violated my fundamental right. There is a difference between appealing from the High Court to the Supreme Court and appealing against the High Court to the Supreme Court. If higher judiciary was state, then higher judiciary will not be able to pronounce on constitutionality of laws. The judiciary's job is judicial review. No law can violate fundamental right. Yes. And fundamental rights are available against the state. So state cannot violate your fundamental rights. If higher judiciary is state, then higher judiciary can never violate your fundamental rights. If higher judiciary can never violate your fundamental rights, then higher judiciary can never impartially decide whether a right has been violated or not. Because every time the higher judiciary says a right has not been violated, the higher judiciary has violated your right. Yes? So to preserve judicial review, which is basic structure, higher judiciary is exempted from state. Yes? If writs are against fundamental rights are against the state, higher judiciary is not state, writs cannot be against higher judiciary. Basic CSAT. Yes or no? So that is why neither the Supreme Court can issue a writ to the High Court, nor can the High Court issue a writ to the Supreme Court, nor a larger bench of the High Court can issue a writ to a lower bench of the High Court, nor can a higher bench of the Supreme Court issue a writ to a lower bench of the Supreme Court? Do we understand this? Yes. This is the ecosystem. So therefore, higher judiciary is exempted. A writ of habeas corpus in your prelims, if there is a question, cannot be issued against the Supreme Court or the High Court. That would be a correct statement. Yes. Now comes the issue of lower courts. Can lower courts be under the purview of habeas corpus? Lower courts have the power to apply the law. Lower courts have the power to grant custody. That custody could mean judicial custody. It could mean police custody. That custody could be legal. It could be illegal. So custody could be detention. It could be illegal detention. So a lower court can illegally apply the law and can illegally guarantee illegal detention. So a writ of habeas corpus technically can be issued against a lower court. Yes. Now hold on to that thought, because while technically you can, the larger question is, why would a lower court pass an order illegally detaining someone? One out of the following things would have happened. One, the court would have not had the power to do so. What is illegal detention? Somebody has illegally detained you who does not have the power to detain you. Yes, that's the first part. So if you apply that logic, maybe that specific court did not have the power to order detention, and they have. Are we clear on this? That could be one reason, simple one reason. The second reason could be that the law which is being applied by the court does not allow for detention, yet you have given detention. Again, what has basically happened here is, whenever the lower judiciary has illegally detained you, it has crossed its jurisdiction. It has given an order that it did not have the power to. Yes. So if a court does something which it does not have the power to, you already have two ready-made writs, prohibition and certiorari. So a writ of habeas corpus against a lower court would effectively come here in the form of prohibition and certiorari, because they have given an order they are not supposed to. Do we understand this? So the nature of a writ of habeas corpus is in the nature of a prohibition or a certiorari. Do we understand this? Good. Which then leaves a larger question. What about a private person? What about a private individual? What about an institution or an organization? Yes. A session court is generally lower than a district court. That's the basic difference. So civil court, criminal court, other name is sessions court, then you have district court. आपको पार्लियामेंट ने एथिक्स कमेटी में बुलाया, दरवाजा बंद कर दिया. There is a privileges committee. Every house has a privileges committee. You have breached privilege. The privileges committee is examining your case. You are sitting with them in a room like this. They lock the room from outside and go. नहीं. Privileges apply to everyone. Can only judges commit contempt of court? Then contempt of court, privileges and defamation are three sides of the same coin. Defamation is damaging a person's reputation. Contempt of court is damaging the court's reputation. Privilege is damaging the parliament's reputation. अगर illegal है तो फिर question करो. Privilege is committing. Privilege is committing. So whenever there is a breach of privilege, the general Lok Sabha parliamentary procedure is you transfer it to the Privileges Committee for examination. Then the Privileges Committee will conduct an inquiry. And by principles of natural justice, you would be asked to present your case. You can be locked from outside. Then, simple as that. Okay? Now comes the larger question. What about a private person? If I lock the door and then go, then but you can't leave the room. Who? How? I'll take your phones away. जाके दिखा. Agreed. Don't get caught up in the details of it. Answer this question logically. Can there ever be a criminal law allowing a private institution to detain anyone? No. There can never be a criminal law allowing a private institution to detain anyone. No way whatsoever. Yes? So then tell me, if a private school as a form of punishment detains a child, illegal hai? Detention as a form of punishment is fundamentally illegal. No criminal law of any nature whatsoever will ever give a private institution the power to detain. So if a private person is detaining you, it is de facto illegal. In fact, it is a crime. This crime, as he rightly said, could take the form of abduction or kidnapping. The difference is major and minor. You kidnapped a child, you abduct an adult. If a private person is detaining you, Baba, they are abducting you. So, just be very careful of this. If a private person is detaining you, they are abducting you. So, it is a crime. So, then comes the question, can a writ of habeas corpus be issued thereafter? It's a crime. You will have police. The police will facilitate your rescue. Yes. But is your fundamental right or your legal right anywhere being violated? Article 19 is only for the state, and Article 19 is only for the citizens. Article 22 is protection against arrest and detention. Yes or no? So if a private person is illegally detaining you, what fundamental right of yours is being violated? On what grounds are you going to go to court? 20 is a general criminal principle. Private school is also state. Acha, kaise? But this is, it's performing a public function implied. But this is not just about a private school. This, then, what are you going to do? Law is a precise endeavor. Article 19 clause 1 says all citizens shall have the right to. It does not say the state shall ensure. Article 19(1) says all citizens shall have the right to A. Freedom of speech and expression, B. Peaceful assembly without arms, C. Association, union, cooperatives, D. Movement, which means all citizens have a freedom of movement, irrespective. That movement can be restricted by the state, but it is not necessarily just against the state. So that means Article 19 can be interpreted as a right taking away your freedom of speech and expression as a right against private. Any? So, Article 91D can be interpreted as a fundamental right against state and private. So, hypothetically, you can go to the court seeking a writ. Clear? Understood? But there is a problem. You can go to the court seeking a writ against a private person for illegal detention, agreed. But this can never be directly possible. Why? Because we discussed this. You can only come for writs if you have no other legal remedy. In this case, you do. In this case, you have the legal remedy to approach the police. So while this is theoretically possible, it's practically improbable. Now do you understand? While it is theoretically possible, it is practically improbable. Because the police necessarily has to take cognizance of missing persons. They have to necessarily act on a missing person's report. Are we clear on this? Yes? Excellent. Yes. क्यों कहते हैं? क्योंकि the judicial function of the lower court is not interpretation of the law. It is application of the law, determining a question of fact and law. Has X incident happened? Is that X incident a violation of the law? ये दो काम है. There is no validation and invalidation of a law. There is no interpretation of a law. There is no filling the gap or a void in a law. The lower judiciary simply applies the law as it is to a determined set of facts. मैं सड़क पे चल रहा हूँ, कोई मेरे को चाकू मार दिया. Very possible. मेरे वजह से बहुत तकलीफ है उनको. चाकू मार दिया. मार देंगे? पक्का, बट मेरा चर्बी इतना कि घुसेगा ही नहीं चाकू. That's a different story. Two things have happened, boss. One is stabbing somebody. Did somebody stab me or not? क्या मेरे को चाकू मारा कि नहीं मारा, उसने मारा कि नहीं मारा. These are facts. हाँ, और क्या चाकू मारना गलत है कि नहीं. अगर लॉ में गलत है, then you apply the law. Do we understand this? Are we clear on this? Yes. Illegal है ना. If the police is detaining you illegally, the police is detaining you illegally. The police is executive. अब वो प्राइवेट उनको बुलवा के करवा रहा है, कहलवा के करवा रहा है, वो तो बात ही खत्म हो गई. The second you have been detained by the executive, it doesn't matter why the executive is doing it. If it is illegal, it is illegal. Clear? Now, तो दोबारा करेंगे. हाँ, और क्या. जिंदगी में प्यार एक बार होता है, टूटता भी एक बार है, सब एक बार होता है. ठीक है, तो इनको एक बार किडनैप किया, हम एक बार कूद जाए. इतना क्या खास है आप में कि आपको 2 बार किडनैप करेंगे. राइट. नाउ द नेक्स्ट लॉजिकल स्टेप. This is a court. The power of the court to hear a case is called jurisdiction. Yes, the power of the court to hear the case is called jurisdiction. In fact, the power of any authority to do anything is called jurisdiction. Right? Now, there is one simple question. On one hand, does the court have jurisdiction or not? That we will deal with prohibition and certiorari. The second part, who are you? आप क्यों आए? For example, yesterday when there was a function going on, we went downstairs. We spoke to them that could you please give us 20 minutes of respite. Who are we? We were affected by what was happening on the road. It affected us. We were a party to it. Our rights were being violated. So, there is another word called locus standi. The capacity of the person to approach the court. Who are you? Do you have to be related to the case? Now, in illegal detention, think about it logically. You are illegally detained. You cannot go to court. Somebody on your behalf is going to go to court, which is why in habeas corpus cases, locus standi principles are relaxed. You don't have to be related to the case. Your friend, relative, sibling, father, mother, they can go to court and file a habeas corpus petition on your behalf. Because if you can come to court, then you're not illegally detained, na? Imagine coming to the Supreme Court and saying, my lord, please issue a writ of habeas corpus against Papa. He has illegally detained me. The judge is going to ask you, but you are here. Yeah, but in the evening he doesn't let me go out. Do we understand this? Yes. When you start relaxing this even more, this leads to the birth of public interest litigation. That it is affecting the public at large. It's not affecting you specifically. It's a larger issue. You are effectively diluting or relaxing principles of locus standi, which you would do in cases of habeas corpus. हाँ, बिल्कुल बिल्कुल. Understood? Yes. Now, Mandamus is clear. Sorry, habeas corpus is clear. All right. Now we come to Mandamus. Mandamus is the widest used writ. Mandamus is the widest used writ. It's the most common used writ. Now, Mandamus in one simple line means that the court is asking you to do something. That asking you to do something could mean asking you to do something, or could also mean asking you not to do something. Telling you do this, telling you don't do this. Yesterday we were discussing cancellation of 2G licenses, cancellation of coal blocks. You basically issued an order of mandamus. You basically issued a writ of mandamus. The Supreme Court issued a writ of mandamus to the Telecom Ministry, directing them to cancel 2G allocation, because allocation of 2G was not in public interest and was collectively violating the rights of citizens. It was a PIL. Are we clear? Similarly, the Supreme Court ordered the Coal Ministry to cancel coal block allocations, right? So, mandamus is basically an order to do something or to abstain or not to do something. What is that to do or not to do? Public duty. Whenever a public office fails to do their public duty, or doesn't do their public duty, or incorrectly does their public duty, that's when your fundamental right gets violated. That is how. So you simply tell the concerned person to perform their public duty. That concerned person could be anyone as long as they have a public duty to perform. Clear? And the Supreme Court has therefore taken a very, very broad view of this writ. Very broad view of this writ. Okay. Now, generally what happens is, nowadays we are seeing a different kind of mandamus called a continuing mandamus, which means in public interest litigation cases, the Supreme Court continues to issue one writ after the other. That, okay, this is an environmental case where the construction of an airport is going to cause damage to this village. Stop the construction. Stop the construction of the highway. Stop the construction of the hotel next to the highway. These are called continuing mandamus. Supreme Court, this is in fact the most widely used writ. Most writ petitions in the Supreme Court or in the High Court are in the nature of asking mandamus, and the Supreme Court has a very liberal interpretation of the writ of mandamus. Right? Now, whether the person is supposed to do something or not supposed to do something, ultimately it is about public duty. So categorically, when you file a writ of mandamus before the Supreme Court or the High Court, you have to specifically ask them to perform a duty. That performance could also mean non-performance. That performance could also mean an act of omission, could also mean an act of abstention. But do your job by not doing this, or do your job by doing this. This is categorically necessary. It is compulsory in Mandamus to ask for specific action. वहां जाके रोने गाने नहीं जा रहे कि हाय देखो सरकार क्या करती है. Very specific direction of the court is sought in a writ of Mandamus. Are we clear on this? Yes. Now, so therefore, the primary purpose of the writ of the Mandamus, of the writ of Mandamus, is to compel the performance of these public duties by these public offices guaranteed under the law, guaranteed under a statute. So a writ of Mandamus is one of the closest ways to uphold what is called rule of law. Understood? Clear on this? Yes. Now, let us see who it applies to, who does it not apply to. ठीक है, चलिए. Legislature. There is a public duty the legislature has to perform. What is the legislature's only public duty? Making laws. Yes. Can I issue a writ of Mandamus to the legislature asking them, go make a law like this now? Can a writ of Mandamus be issued against the legislature, specifically commanding the legislature to make a law? Nope. They can suggest, they can request, they can never command a legislature to compulsory make a law. Even in triple talaq, they declared triple talaq is unconstitutional and suggested to the parliament, why don't you make it a criminal offense? You should. Doesn't mean you have to. You will never ever see a Supreme Court order giving a deadline to the parliament to make a law because of simply rule number 3, separation of powers. This would violate separation of powers as it is. So therefore, a writ of Mandamus technically cannot be issued to the legislature because their only function is to make laws. रिक्वेस्टिंग होता है, ठीक है? नहीं, विशाखा केस में तो हम ही ने कानून बना दिया था, कोई रिक्वेस्ट नहीं था. The Vishakha judgment was in itself a law in the cloak of a judgment. It is called a judicial legislation. वो जजमेंट में उन्होंने कानून ही लिख दिया जजेस ने बैठ के कि ये कमेटी बिठाओगे, ये मेंबर होगे, ये पावर होगी, ये काम कराओगे, प्राइवेट में भी लगेगा. ये तो कानून बनाना हुआ ना. If you read the Vishakha judgment has the composition of sexual harassment committees, the powers of sexual harassment committees, the applicability of those, will government and private both have them? ये सब विशाखा गाइडलाइंस में लिख के दिया है, तो कानून ही बना दिया. That in the eyes of separation of powers is not acceptable. Judicial legislation is a form of judicial activism. It is in fact closer to judicial adventurism more than activism. ठीक है? Anyway, so legislature को नहीं कर सकते. नहीं, आप कमांड किसको कर रहे हो? Are you commanding the legislature to make? एक तो हाथ खड़ा करके पहली बात. दूसरा, are you commanding the parliament to make a law? No. Whenever you make a law, you make a law. Until then, my judgment runs. आपसे पूछ नहीं रहे, बता रहे. Understand the difference? Yes. Judicial legislations are extremely problematic. Extremely problematic. And he has a fantastic question. judicial legislations are not a form of mandamus, because you're not directing somebody to do something. A judicial legislation is a judgment which itself gives you guidelines to be implemented. A judicial legislation is not telling you to do something, it is doing it itself. ठीक है? Very good question. Now comes executive. एग्जीक्यूटिव में हाँ भी है और ना भी है. अब ये हाँ तो आपको पता है, public duty is the function of the executive. If the executive is not doing their public duty, you issue a writ. But what about the executive can you not issue a writ for? What about the executive can you not issue a writ for? If the judiciary can make judicial legislation, the executive can make delegated legislation. Motor vehicle rules, mines and mineral rules, RTE rules. These rule-making powers of the executive are given to the executive by the legislature. So a mandamus also cannot be issued directing the executive for delegated legislation, commanding the executive कि अब ये rule बना दो, जरूरी है. Do we understand this? If the legislature cannot get a mandamus, the executive for delegated legislation can also not get a mandamus. Are we clear on this? Yes? Good. Now, judiciary. Same thing. Now think about judiciary. Judiciary. Yes. Higher judiciary and lower judiciary. So the lower judiciary part is same as prohibition certiorari, that if the wrong court is hearing you, then you can order the wrong court to stop hearing you and order the right court to hearing you. So as far as lower judiciary is concerned, you have a dedicated writ of prohibition and certiorari. Fair enough, makes sense. My issue is with higher judiciary, because the writ of mandamus is directing the Supreme Court or the High Court to perform a certain function, to perform their public duty. This is about public duty. So can the Supreme Court direct the High Court to perform a public duty? कि आपको ये तो करना पड़ेगा, ये तो सुनना पड़ेगा. Nope. You have absolutely no mandamus in higher judiciary, because if that happened, then you would take judicial review away. Then the whole High Court, state, everything else goes away. Go back to basics. A public duty is to be performed by the state. If higher judiciary is not state, they are in the eyes of the law not performing what is called quote unquote a public duty. So writ of mandamus cannot be issued against the High Court. Okay? Now obviously not against the private also, because the private does not perform a public function. Here is where it becomes interesting. The second a private organization is considered state under Article 12, then mandamus can be applied. And for a private person to be considered state, There are these multiple tests that we have covered. Airport Authority, Rajasthan State Electricity Board. So yes, so BCCI's case. So then you are state. So can a writ of mandamus be issued to BCCI? No, because BCCI is not state as per the Z Telephones case of 2005. So based on the judgments, who is state and who is not state is decided on a case by case basis. It is not a blanket order. It is incorrect to say all schools and all colleges are state. There is a Supreme Court judgment which says universities are state. So all of this evolution has happened on a case to case basis. There is a dedicated case which says the Food Corporation of India is state. There's a dedicated case, we've done this in class, which says ONGC is state, LIC is state. If the organization is state, then you can file a mandamus. If the organization is not state, you cannot. My problem is, this is where the UPSC messed up. Because last year they said, mandamus cannot be issued to a government company. If you are a government company, which means government holds a majority stake, that means you are state by the definition of state. That means mandamus should be applied to you. There is no way in hell that option is correct. But in the official answer key, they have marked it as correct. Yes. This is proof that the UPSC also makes mistakes. But that 1 mark would have costed somebody's prelims. Yes. To say a government company is not state is just, it is a clerical error. It is no other answer but a clerical error. Okay? A government company is state. There is no reason a mandamus cannot be issued to a government company. अभी ONGC को किया ना, LIC को किया ना, specific case laws है. RACB and airport authorities case have given you guidelines. If your nature of function is public, if you have dominant share ownership by the government, if you have work like a monopoly, oil and natural gas exploration में ONGC के अलावा कौन था भाई? फिर? Then how can you say mandamus cannot apply to a public sector? It can. So for it to apply to a private organization, that private organization must fall under the ambit of state. Because writs are to enforce rights. Rights are available against the state. If you are not state, a writ cannot be issued to you. Simple. Okay? Good. So that takes care of mandamus. Yes. Sure. Delegated legislation means that the parliament or the legislatures, while making a law, will add a section in that law that the concerned ministry can make certain rules on it. Yes, these rules are technical. For example, Right to Education Act will guarantee you a 25% education reservation in private schools also based on EWS. Right to Education rules will tell you what your teacher-student ratio is. This teacher-student ratio can change from time to time. If suddenly you have too many teachers, teacher-student ratio comes down. Yes. And if you suddenly have far too less teachers, then the teacher-student ratio suddenly goes up. Fairly possible. Yes. So my question therefore is, these fluctuations in teacher-student ratios should not be dependent on a law, because every time you want to change teacher-student ratios, You cannot go back to amending the Right to Education Act. It would be very time consuming. It would be very tedious. It is going to be very prolonged as a process. Yes. So therefore, within the Right to Education Act, there will be a section that will say the ministry can make appropriate rules. So you have these rules. The difference between an act and a rules is an act has to be passed, a rule has to be notified by the ministry. The rule can never violate the larger purpose of the act. For example, Motor Vehicles Act says driving without a helmet should be punishable. The motor vehicles rules will give you the nature of fine, the quantum. So every time you want to increase motor vehicle fines, you can't go amending the Motor Vehicles Act. You can quickly just change the rules, have the Transport Ministry issue an order, and you're done. Juvenile justice rules, mines and minerals rules, yes, RTE rules. You can't go amending the law. And these rules also have to be very careful. In fact, delegated legislation in itself is a topic of the executive. It is also a very important part of administrative law. It's a part of the law optional also. Delegated legislation. If the ministry is drafting certain rules, how do those rules exist in correlation with the law? It can't be the case that Motor Vehicles Act says wearing a helmet is wrong and Motor Vehicle Rule says शाम को 8 बजे के बाद खुला घूम लेना. The rules cannot violate the essence of the law. The rules cannot violate the essence of the law. Do we understand this? Yes. 100%? Sure? Excellent. So that is the process. And that is how the process should be. Always. Clear? Now, your follow-up question was, if the court had to direct the executive to make a kind of a law, that means you would again violate rule number 3, separation of powers. This is why a writ of mandamus cannot be issued against the executive for delegated legislation. For everything else, yes, but not for delegated legislation. ठीक है. Suggest तो you can, Supreme Court का दिन भर काम ही है. ठीक है. ना, sorry. हाँ वो ठीक है, बट ये थोड़ा ना बोले कि कल तक बना के दे. कल तक नहीं बनाया तो निपटा दूंगा मैं. ठीक है. Now we look at judicial writs, which are the writs of certiorari and prohibition. We will look at them collectively. ठीक है, collectively. The basic understanding of prohibition and certiorari is wrong court, case pending, wrong court, case decided. Bas. That is all that there is. So, prohibition is wrong court, case case pending, and certiorari is wrong court, case decided. मतलब कंज्यूमर कोर्ट मर्डर केस सुन रहा है, प्रोहिबिशन. कंज्यूमर कोर्ट ने मर्डर केस में फांसी की सजा दे दी, खत्म. ये डिफरेंस है. द सिंपलेस्ट डिफरेंस बिटवीन प्रोहिबिशन एंड certiorari. Prohibition is wrong court, case pending. Certiorari is wrong court, case decided. Now, you don't have to think about it just as a court. You think about it as something else. What does a court do? Sorry. हाँ बता दो 2 मिनट ठीक है. Now, when I say court, I don't just mean high court, lower court, district court. I mean any form of judicial or quasi-judicial body. Any body. Now comes the larger question, and pay attention to this: a judicial body and a quasi-judicial body. We'll start from what your question was, because the answer is there. See, we understand the court is a judicial body. Everybody agrees with this? अब मैं basic maths करा रहा हूँ, ये बहुत important है. It will relate to a lot of things. We understand that the court is a judicial body. Yes. A judicial body is anyone who performs a judicial function. A judicial function is a collection of two things: a question of law and a question of fact. Yes. A question of law and a question of fact. Did the incident happen? And was the incident a violation of a crime? Both of these two things. ठीक. So therefore, my first equation is a judicial body is a body which performs either a question of law, a question of law and a question of fact. ये सही बात है? पक्का? Any problem with this equation? We're okay with this? If I divide LHS and RHS by 2, by half of a judicial body, and these are absolute terms, would perform at least a question of law or a question of fact. Yes or no? Yes. The synonym, paryayvachi, of half a judicial body is a quasi-judicial body, performing at least a question of law or a question of fact. Yes. Excellent. Now, we remember legislature, executive and judiciary. We remember, for example, Lok Sabha, Rajya Sabha, elected executive, permanent executive, Supreme Court, High Court, etc. We are looking at rule number 3 and rule number 4. We also understand that we have to keep a check on the actions of the elected executive. Yes. We understand the elected executive is ultimately responsible to the Lok Sabha, and this kind of responsibility is extremely strict responsibility. Extremely strict. This kind of responsibility is extremely precise. सीधा no confidence motion, सीधा adjournment motion, सीधा censure motion, उसके नीचे बात ही नहीं करते, right? And there has to be some form of joint accountability as well. Yes. Which is why you have the institution of parliamentary committees. Yes or no? Correct. Now the parliamentary committees will now examine executive action. Yes. कहाँ पैसा खर्च किया, क्यों किया, कैसे किया. Now these are generalists. These are specialists. The only other person who has that kind of expertise to give parliamentary committees that kind of information is the permanent executive. But the permanent executive is appointed, the elected executive is elected. They will eat them up every day on a daily basis. Yes. So I will have to give some of these permanent executives some special protections in the constitution, that you will have a fixed tenure, will be very difficult to remove you, your salary would be protected, your office would be protected. I'll provide these kind of constitutional protections to you, to some of you, so that you can perform the larger function of checks and balances. And that is why you're called constitutional bodies. A constitutional body is not called a constitutional body just because it is mentioned in the constitution. It is called a constitutional body because it has been given additional constitutional protections as they are performing a very crucial function of checks and balances within the executive framework. And this is why ultimately their reports have to be tabled before the parliamentary committees. यही होता है, कहानी यही है. Are we clear? Now comes the larger question, and if you look at it carefully, these constitutional bodies are performing similar functions as that of the Supreme Court without being the Supreme Court. ये अंदर से वार कर रहे हैं, Supreme Court बाहर से है. They are also reviewing action. They are also reviewing action. So those constitutional bodies who are performing those advanced check and balanced functions should be treated similarly like the Supreme Court. Because ultimately, if India's highest national judicial body is the Supreme Court, right? Then India's highest national quasi-judicial bodies should also be treated like the Supreme Court. काम तो वही कर रहे हो? Because between a judicial body and a quasi-judicial body, at least a question of law or a question of fact is common. And the one constitution body which performs remarkably similar work, it cannot strike anything down, but it looks at, yes, it looks at exactly the same thing. It gives you exactly the same precision, is Comptroller and Auditor General, which is why CAG has the same removal as that of a Supreme Court judge, which is why CAG is the only constitutional body whose oath is mentioned in the schedules of the Constitution. ठीक है? कहानी ये है, होता है तो क्यों? And therefore, any quasi-judicial body, for them to take an action, they should have the jurisdiction to do so. We just discussed jurisdiction and locus standi. Yes. That is why we have a problem with CAG. You tell me whether I have spent my money properly or not. You tell me if there are any leakages or not. Don't tell me where I should have spent my money. मेरे को नाला बनाना है, मैं नाला बनाऊंगा. मेरे को कुआं बनाना है, मैं कुआं बनाऊंगा. आपका काम है चेक करना कि कुआं गहरा है कि नहीं. और अगर 100 करोड़ का कुआं है तो 100 करोड़ के लायक का कुआं है कि नहीं. मेरे को ये मत चिपकाओ कि कुआं नहीं बनाता ना था, सड़क बनानी थी. मेरी मर्जी, मेरी सरकार, मैं इलेक्शन जीत के आया हूं. And this is why one of the strongest arguments against CAG is a policy audit. Don't undertake policy audits. Do we understand this? Yes? Are we clear on this? Excellent. So, my understanding is quasi-judicial bodies must necessarily have some or the other form of jurisdiction, some or the other form of capacity to hear something. So when we talk about prohibition, the origins of the prohibition writ actually go back to common law, because a lot of times in the era of the king, a lot of times you had organs, courts, agencies which would hear cases that they did not have the power to, largely because you will see wrong cases, wrong courts mostly in unwritten constitutions. In a written constitution, in a single law, it is all focused in one place, concentrated in one manner. Yes or no? So therefore somehow we've got this part right. Okay? Understood this? All right. So in one line, what is prohibition? Prohibition is nothing but stopping other courts from entertaining matters that do not fall under their jurisdiction. When I say court, I say any court or any judicial body. That's all. Any court or any judicial body. Are we clear? Now, with Mandamus, Locus Standi rules are still stricter. With Prohibition and Certiorari, you may have been sent to jail, your bail may have been denied, you may be under trial. So, Locus Standi rules may not be strict. They can sometimes be relaxed, they can sometimes be strict. It depends from case to case. Very good. So, therefore, any tribunal, any quasi-judicial authority, any court, whenever they are entertaining a matter, whenever they are hearing a matter which is something that they don't have the power to, you immediately go for a writ. Understood? Yes, a writ of prohibition. Now comes the important part, and listen to this carefully. A writ of prohibition is for an error in jurisdiction, not for an error in law. This isn't about you have interpreted the law wrongly. This isn't about you have applied the law wrongly. This is about you don't have the power to hear this, period. Good, bad, right, wrong, your decision does not matter. Prohibition is for an error in jurisdiction. It is not for an error in law. Completely not for an error in law. Now, generally, what happens is, in practice, generally, very rarely will you see prohibition writs to be granted. Because for a court to say that that court does not have the power to hear this case is demeaning on both sides. It's not very obvious कि civil case आपको murder कर रहा है, ऐसा नहीं होता. What generally would happen is, for example, I'll take a case that affects you. So a lot of times, and this is how we actually do it. For a lot of times, for example, what has now recently happened is, I'm looking into 2 more cases since 3 days ago. 2 things have happened. One, and this is a real issue. Are you aware of a UPSC exam called CAPF, Central Armed Police Forces? Very interesting case. So these candidates had appeared for the CAPF. They all cleared it. They all appeared for the interview. Now after the interview, you have to go for a medical. In your case also. But the difference between their medical and your medical is not extremely serious. Their medical is extremely serious. It's not as strict as an army medical, but it is also not as chill as a civil medical. It's somewhere in the middle. Now, the fact of the matter is, people write the CAPF after 2 years of civil services. There are very few people who dream of CAPF कि मेरे को असिस्टेंट कमांडेंट बनना है BSF. इतना ही है तो फौज ज्वाइन करो. Nobody aspires as their first choice to get into paramilitary. If you have such a craze, you would want to get into the military, because it's the army that gives you everything that the paramilitary does not give you. The opportunity to serve, a quality of life, perks, etc., everything. Anyways, so children who generally write this are children who would have been writing this exam for 2-3 years. They would obviously be a little stressed. They would obviously have a little pressure. Now, when you go for these medical tests, your BP is taken. And if your BP is beyond a normal point, hypertensive, most of you would be hypertensive. You would have stress. Most of your BP will be more than 120, easily more than 140. Then the rule is, you are admitted to the same hospital for one entire day. And after a duration of every 45 minutes to 1 hour, your BP is taken. And if your BP is within the limits, you are declared as fit. So what ITBP in one of their base hospitals in Lucknow did was took BP of all 18 students in 1 hour, 6 times in 1 hour, instead of 1 every 6 hours. Declared all of them as unfit and sent them home. Case number 1. Case number 2. The Forest Services has now released a notification, not publicly, for its officers. The current batch of the Forest Services, received a letter from the environment and from their DG Forest Services Institute and MOEF. If you are a Forest Services probationer, you cannot write the civil services again for the next 2 years. Yes. अभी 1 महीने पहले आया. Again, with all love to the Forest Services, there are very few people who want to become Forest Service officers. If you have a technical background, then you will also look at this in addition to the civil services, though the Forest Services is also a remarkable career in my own understanding. Anyways, do we understand this? Yes? In both of these cases, Article 14 is violated. Article 16 has been violated. Equality in public employment. 21 has been violated. Principles of natural justice has been violated. Yes or no? Good. So, I have enough fundamental rights to go to the Supreme Court or the High Court directly. But I have to think, is this a rights issue or a rights recruitment issue? It's a recruitment rights issue. For me to go to the Supreme Court or the High Court directly under 32, I should have no other legal remedy. In both of these cases, we have set up something called the Central Administrative Tribunal. So I will have to first go there. Because if I don't, and if I go to the Supreme Court or the High Court, all that the UPSC's lawyer has to come and say is, my lords, the cat has jurisdiction. It does not concern the court. They will never say, आपकी सुप्रीम कोर्ट में आके नहीं बोलेंगे कि आपकी औकात नहीं है ये सुनने की. उनकी औकात है सब सुनने की. But वो बोलेंगे, if there is a dedicated cat set up for recruitment issues, and these are recruitment issues. This is not a policy issue. You have cleared the exam, you are in the final stages, or you are already in service. Now your conditions of the service have been changed in a way that they are at your disadvantage. So I will have to go to CAT. Understood? Are we clear? So in reality, prohibition works this way. Very rarely do you see prohibition issued. So what will happen is, if I go to the Supreme Court or the High Court, the UPSC lawyer will come and say, please don't do this, ये इधर नहीं, CAT जाना चाहिए. तो फिर मैं ऐसे हाथ जोड़ूंगा. My lord, I know we have to go to CAT. But if I go to CAT directly, CAT is slower than most district courts. It is an extremely slow tribunal. सब जुगाड़ पे चलता है वहाँ. कुछ कोई मतलब Supreme Court spoils you to practice in terms of things are the most organized. Then High Court, and then High Court of Delhi actually. Not like Bhopal and like MP and Lucknow, Allahabad High Court and Delhi High Court. Gwalior, sorry. Please go. Now what generally happens is this. While UPSC's lawyer is saying, नहीं, CAT जाना चाहिए, मैं इससे literally हाथ जोड़ता हूँ. My lord, I beg you to just give me an order saying go to CAT and please order the CAT to hear this in 30 days. कि 30 दिन में मेरे को judgment चाहिए. That is how you play with the law. Now when I go with the Supreme Court order to CAT, I'm like, hey, पापा से लिखा के लाए हैं, 30 दिन में मेरे को ऑर्डर खत्म चाहिए. Do we understand? That's how the law works. That is why इधर से घूम के आते हैं. Because otherwise it is very difficult to prove urgency in CAT. हाँ ठीक है, नौकरी मिल गई ना, तो ठीक है. यूपीएससी हमारा भी नहीं निकला, नहीं मिल गई ना, मिली कि नहीं मिली. अभी आपके पास सरकारी नौकरी है कि नहीं है, बस. तो क्या हुआ? प्रीलिम्स में 6 महीने है ना, 2 महीने बाद बात करें, बैठे रहो. It is very stressful. Do we understand this? Yes? Clear? So that's the idea. Certiorari on the other hand, ठीक है? Certiorari on the other hand is the wrong court, but the case has already been decided. Now please understand what this means. It is a call from the higher court to the inferior court for a record of its proceedings. कि भाई क्या किया है, क्या ही मचाया है, right? Prohibition is error of jurisdiction. Certiorari is error of jurisdiction and error of law. Both apply in certiorari. Here is error of jurisdiction. Certiorari could be error of law also. That you have wrongly applied the law. You have wrongly interpreted the law. You have wrongly given a sentence. Very possible. Clear? So generally what happens is, whenever there is an error of jurisdiction and an error of law, then the superior court can either cancel the order or can transfer the case to itself. Can either transfer the case to itself or can cancel whatever order has been issued so far. Are we clear? A high court cannot issue this to another high court. A Supreme Court also cannot issue this to a lower high court. You must understand this, because this would take away judicial review. In fact, one bench of the high court can also not issue this to another bench of the same high court, of any other high court or whatever. Are we clear? Understood? You also can't use the writ of certiorari to ask for Supreme Court intervention. कि इनसे हो नहीं पा रहा है, आप देख लो. उसके लिए special leave petition है. And special leave petition is a completely different set of guidelines. There has to be a substantial question of law. There has to be a genuine violation of justice. Then you will have a special leave petition under Article 136. Not under certiorari. Are we clear? Understood? Yes. Now, please understand this. No doubt, higher courts, high court of states are lower courts to the Supreme Court. No doubt, high court of a state is an inferior court to the Supreme Court. Completely agreed. Completely. And I agree, high court judgments are rectified by the Supreme Court. They are. High court would have interpreted something as X. Supreme Court would overrule a high court judgment and interpret it as Y. It has happened so many times. But that does not mean it falls under the ambit of 32 or under the ambit of certiorari. ये बहुत fine balance है. When I'm saying there is an error of jurisdiction or an error of law, a high court could have committed error of law. A high court could have wrongly interpreted it, could have wrongly applied the law, and the correct interpretation would have been given by the Supreme Court. That still does not mean you can go to the Supreme Court with a writ of certiorari against a high court. Because both of them are courts of record. Both of them have powers of contempt. Both of them have powers of judicial review. Both of them are constitutional courts, which means both of them have the power to interpret it. Even if the High Court has interpreted a law wrongly, it has the power to do so. You may not agree with it, and if you are the Supreme Court, you can overrule it. Absolutely no problem whatsoever. If you are the Supreme Court, you can overrule it. But that does not mean the High Court is any less. So in this case, when we look at its applicability, will it apply to the legislatures? No. Right? No. But my question is, if the legislature is acting like a quasi-judicial body, yes. Yes. Okay. Now give me an example of when the legislature acts like a quasi-judicial body. Committees. Yes. Baba, when you're removing the president, you're removing the vice president, when you're removing anybody, any removal function of the legislature is a quasi-judicial function. Do you know almost all presidential elections have been challenged in a court? Yes. Almost all presidential elections have been challenged in court. Court has not entertained. I said, pagal hai kicha. But they have been challenged. So, when the legislature is performing a quasi-judicial function, then yes, of course. Of course. Especially in that case, can prohibition be issued? No. It's not a question of jurisdiction. It's generally a question of error of law. Yes or no? There are greater chances of certiorari to be issued against the legislature than prohibition, because it's not a jurisdiction issue. It would generally be an error of law issue. Are the grounds correct? Were the procedures followed? So on and so forth. Do we understand this? If this was not the case, then you would not be able to review any parliamentary action. Today you can even review a speaker's decision on anti-defection. Yes or no? Then if the executive is acting as a quasi-judicial body, yes. Tribunal, commissions, commissions of inquiry, yes. And with judiciary, we already know higher judiciary, no. Lower judiciary, yes. Give me 2 minutes, I'll answer the questions later. Are we clear? Good. Now, because the action against you may already be in motion, because the decision against you may already be in motion, so your locus standi rules have to be slightly relaxed. आपका bail deny भी तो हो सकता है. Very, very possible. Do we understand this? Yes? Now, Quo Warranto. In one line, the final writ, Quo Warranto means usurpation of public office. Usurpation of public office. Now please understand, what does this mean? तू इधर आया कैसे? That is the literal meaning of Quo Warranto. ठीक है? For example, this writ was one of the most open-ended writs. कि आपका अथॉरिटी कौन है, आपने किस पावर में किया, किसने आपको ये अलाउ किया. Here the Supreme Court has given a very clear interpretation. A writ of Quo Warranto can only be issued, one, if the person who's holding the office does not have the qualifications to hold the office, and two, the appointment of that person to the office was a violation of the rules governing that appointment. Do we understand this? There are only and only two cases, please understand this, where Quo Warranto can be used. You don't have the eligibility to hold that office, and your appointment to hold that office has not been done as per the rules, as per the procedure. So Quo Warranto is actually a very, very heavy administrative writ. In administrative law, you will see Quo Warranto being used a lot. आप लोग भी एक दूसरे के खिलाफ Quo Warranto ही करेंगे. जब किसी का प्रमोशन आपसे पहले हो जाएगा, किसी को यूएन का पोस्टिंग मिल जाएगा, कोई एडिशनल चीफ सेक्रेटरी आपसे पहले बन जाएगा, तो फिर आपका तन तन जलेगा. You're all the same batch. फिर लड़ते रहेंगे, फिर मेरे पास आएंगे, फिर मैं बोलूंगा मैं अपने बच्चों में भेदभाव नहीं करता. हाँ, रिश्वत दे के लगाओ तभी गलत हुआ ना भाई. Legit, just because you paid. एक तो 1 second. Okay, if you paid for a posting, doesn't matter, it is wrong. It is wrong. हाँ, आप तो निपटेंगे, मैं देखूंगा उसका. Correct. Great question. क्वेश्चन बढ़िया लगा मुझे, जेन्युइनली, दिल से. इस क्वेश्चन इज बहुत प्रैक्टिकल क्वेश्चन है. अगर आपको फॉर एग्जांपल आप IRS में है, let me first give a disclaimer. At no point of time do I promote corruption in civil service. It is my absolute unconditional view that you should not be doing this. Yet you will do this. So please don't do this. Okay. Let us say you are in the IRS Bombay has a port called JNPT. Yes, it's a big port. Big port. Lot of import export. Cream posting. Cream posting requires for application of cream. क्रीम पोस्टिंग के लिए क्रीम देना पड़ेगा, तो क्रीम दिया. सपोज आपने क्रीम दिया, वो ऑनेस्ट है, उसने कहा इसको कैसे बना दिया. Quo Warranto is, are you eligible to become JNPT Port Commissioner? Yes. Has your appointment been done as per statutory rules? Yes. Your appointment is perfectly legal. Is it immoral? Yes. Can he file for corruption case against you? Yes. But he cannot go to the court saying Quo Warranto. जज को क्या बोलेगा? मेरा बैचमेट पैसा दे के पोर्ट कमिश्नर बना है, क्यों वारंटो माय लॉर्ड. माय लॉर्ड बोलेगा इतना इतना, मेरे को पता तेरे को क्यों बनना है, तेरे पास कम था ना, सच बोल. Do we understand this? Yes. Now please understand, sometimes a person may be wanting to do this in secrecy, would not want to disclose their identity. Maybe an action of a person would have put somebody in some form of misery. So a lot of Locus Standi rules do not apply. Please understand, Quo Warranto is about eligibility. It is not about suitability. It is about eligibility. Are you eligible to hold that office? Are you the best person to hold that office? मुझे उसमें जाना ही नहीं. It is an eligibility writ. It is not a suitability writ. Are we clear? This is writ jurisdiction. आप प्री में कुछ पूछने दो, मैं देखता हूं आंसर कैसे नहीं आता है. My concluding remarks on writs are: 1. A writ petition is never filed. It is first submitted. There is a prima facie hearing. Then it is accepted कि हाँ कुछ तो दम है. फिर दूसरी पार्टी को नोटिस इशू होता है. ठीक है. फॉर एग्जाम्पल लेट अस से दिल्ली मेट्रो मेरे को चढ़ने नहीं दिया, बोला मोटा गेंडा बैठ जाएगा, फट जाएगी. वेरी पॉसिबल. बट तू तो चली. Habeas corpus is law's way of saying आओ कभी हवेली पर. मेरे को दिल्ली मेट्रो करलबाग मेट्रो स्टेशन में चढ़ने नहीं दिया, बोला मोटा गेंडा बैठ जाएगा, मेट्रो डिरेल हो जाएगी, इलेक्शन का टाइम है, ये सब हम रिस्क नहीं लेंगे. बट मेट्रो पब्लिक प्लेस है, मेरा हक है. लास्ट आई चेक्ड आई वाज अ सिटीजन. ठीक है, तो मैं जाएगा डायरेक्ट सुप्रीम कोर्ट. मैं जज को बोलेगा हालू जज, मेरे को करोल बाग में बैठने नहीं दिया, बोला कि मोटा गेंडा. जज ले वो तो ठीक है, मोटा गेंडा इज नॉट द इलीगल पार्ट. आई सेड हॉट जज, अपने आप को दिखा है. एनीवेज, then I will have to prove to the judge that right to access to a public place is my fundamental right. My 15(1) has been violated. क्योंकि मेरे को मेट्रो में नहीं चढ़ने दिया तो मैं काम पे नहीं आ पाया, तो my 19(1)(g) has been violated. and मेरे को ही क्यों? क्योंकि मैं मोटा गेंडा. You can discriminate on CRRSP. ये F किधर आ गया इसमें? Why are you discriminating on fatness? Yes or no? Correct. जज बोलेगा बात तो सही है. then judge will issue a notice to DMRC कि अच्छा क्यों नहीं चढ़ने दिया मोटे को. Then if the court prima facie in this stage is not convinced that your right has not been violated, they will reject your petition there and then. कहानी बढ़ेगी ही नहीं. Prima facie, the court can reject your writ petition if on the face of it seems like your right has not been violated. कि जोमेटो से खाना मंगाया, खाने में मिर्ची ज्यादा थी, बोला राइट टू लाइफ है वायलेट हो गया. अगले दिन सुप्रीम कोर्ट जा रहे हैं, माय लॉर्ड मेरा ब्लिंकिट 12 मिनट में आया और उसमें मिर्ची था, माय राइट टू पर्सनल लिबर्टी हैज बीन वायलेटेड. माय लॉर्ड बोले इधर किधर है तेरा फंडामेंटल राइट? सर राइट टू फूड फंडामेंटल राइट. वो तो भूखों के लिए है, मोटे गेंडे तो कितना खाएगा? तो मेरा पिटिशन रिजेक्ट कर देंगे. डू वी अंडरस्टैंड दिस? यस. सेकंड, देयर इज अ प्रिंसिपल इन लॉ कॉल्ड रेस जुडिकाटा. इफ कहीं और कुछ और चल रहा है तो कहीं और कुछ और मत करिए. लाइफ का प्रिंसिपल है. समझ रहे हैं कि नहीं? कि कहीं कुछ और चल रहा है तो उसको खत्म करवाइए, फिर आगे बढ़िए, हमें कोई दिक्कत नहीं. बट ये डुअल एग्जीक्यूटिव नहीं चलेगा, है ना कि नहीं? बस यही है. अगर किसी और कोर्ट में देयर इज अ प्रोसीडिंग गोइंग ऑन तो इधर भी पिटीशन उधर भी पिटीशन, क्या लगा रखा है? द कोर्ट विल रिजेक्ट इट. अंडरस्टूड? थर्ड, if an alternate remedy under a statute is available, जब आप डायरेक्टली कैट जा सकते हो, वो आपको वही करके देगा जो मैं करके देगा, तो कैट जाना. मैं सुप्रीम कोर्ट है, मैं केशवानंदा भारती बनाया, तेरा बकरी गाय कौन चुरा के गया ये मेरा प्रॉब्लम नहीं है ना बाबा. अंडरस्टूड दिस? यस. एंड इफ there are disputed questions of fact, remember questions of fact, कि वो नहीं हुआ कि नहीं हुआ. when you come to the Supreme Court or the High Court, this has to be undisputed. ये हुआ, this incident has happened, good bad right wrong doesn't matter. But if the question of fact is disputed, then the Supreme Court or the High Court can reject your writ petition. Simply can ask for a re-examination of your facts. Sorry sir, 2 मिनट लगेगा. sorry 2 मिनट लगेगा. पक्का? ठीक है, आप लोग आराम से बैठो, कोई दिक्कत नहीं. क्लियर? सो एग्जामिनेशन ऑफ फैक्ट्स. when you come to the Supreme Court or the High Court with a writ petition and you've come to a judicial body and they have the powers of question of law and question of fact, if your question of fact is not clear, if there is even an iota of doubt that that incident happened or not, the court will reject your writ. Will say, let us first examine whether the fact has happened or not. Then we will see whether there is a breach of fundamental right or not. Are we clear on this? Yes? ठीक है? Good. On a softer reason, a lot of times these writs are used for political reasons. So sometimes there could be inordinate delays in filing objections, counter objections. This could also be a problem. But for our prelims, we need to know the writs, we need to know their purpose, we need to know against who all can they be issued. The general principle is writs can never be issued to higher judiciary by the higher judiciary. Can only be issued to the lower judiciary, because the reason why a writ cannot be issued to a higher judiciary is the same reason why higher judiciary is not state under Article 12. Got the correlation right? Excellent. ठीक है, done. See you guys at 3 tomorrow. We'll finish part 3, theme 3 completely. You just have basic structure and harmonious construction left. ठीक है? अब मैं बैठ के डीपीएस फंडामेंटल ड्यूटी नहीं पढ़ाऊंगा मैं क्लास में। ये हम लोग ऑलरेडी कंपैरेटिव रिव्यू कर चुके हैं, एंड वी ऑलरेडी डन आइडेंटिफिकेशन ऑफ ड्यूटीज एंड डायरेक्टिव प्रिंसिपल्स, यस और नो? वो हमने फर्स्ट टॉपिक में कर लिया था। सरकार करे तो डीपीएसपी, हम करे तो ड्यूटी, fair enough. We'll do basic structure, harmonious construction and the impact of it tomorrow, and we'll close theme number 3. I'll finish this lecture up, I'll upload it by tonight. ठीक है, चलो, they have a class, चलो चलो चलो, see you. Good afternoon. Good afternoon. Theme number 3, Preamble, Fundamental Rights, Directive Principles of State Policy, Fundamental Duties. Topic number 3, sorry, now we move to topic number 4, the doctrine of basic structure and the doctrine of harmonious construction. Now, first things first, up until now, everything that we were studying in theme number 3 was effectively bifurcated into pre and the mains. We first built the prelims layer, and then we did analysis and built the mains layer. It is in this topic that the process is reverse. You do this with the mains layer, and from the mains layer you extract pre-centric information. Now, as far as the exam is concerned, it is this rare topic which is equally relevant for the pre and the mains. In the prelims, in the last 10 years, there have been 2 questions that have been asked. One was a factual question, the other was an analytical question recently in 2023. The factual question was, when the first constitutional amendment was enacted, who was the Prime Minister? The analytical question was, which of the following constitutional amendments is most known for restricting judicial review? The answer would be the First Amendment of 1951. What is common to the prelims exam is both the questions were around 1951, the First Amendment. Now take a moment and think as to why that is the case. This is the case because everything that happens from there on is an analytical issue, is a jurisprudential issue. But it is the first Constitutional Amendment Act which makes a lot of fundamental changes, right? Now, as far as the mains is concerned, we've had 3 questions in the mains: 2013, 2016, and 2019. Each of these 3 questions, we've done this in our PYQ analysis in detail, but each of these 3 questions had a very specific issue that they were asking. If you listen to the questions carefully, you would understand. In 2013, the mains question was, the Supreme Court of India keeps a check on the arbitrary power of the Parliament in amending the Constitution. The Supreme Court of India keeps a check on the arbitrary power of the Parliament in amending the Constitution. Critically discuss. It does not mention basic structure. It does not mention the doctrine of harmonious construction. It only talks to you about the Parliament's power to make constitutional amendments. This is a key legal issue. The reason this was asked in 2013 is because it was 50 years to the Kesavananda Bharati case, which is 1973. The Kesavananda Bharati case gave you the doctrine of basic structure, which curtailed the powers of the parliament to amend the constitution. But the fundamental issue still remains the power of the parliament to amend the constitution. Do we understand this? Yes? Good. In 2016, there was a specific question in the context of a specific judgment. The question was, what was held in the Coelho case, the Yr Coelho case? In that context, can you say that judicial review is of key importance amongst the basic features of the constitution? Again, did they mention basic structure? No. Did they mention harmonious construction? No. But they gave you a reference to Yr Coelho. And in this case, they asked you the context of judicial review, which is a significant feature of our constitution. Now, first things first, why did they ask this question in 2013? Because 10 years to the Yr Coelho case. So Yr Coelho was 2006, so 2016, the 10-year anniversary, they asked you the Yr Coelho case. Again, the doctrine of basic structure allows the parliament to amend anything in the constitution as long as it doesn't violate certain principles of the constitution. One of those principles is judicial review. And the court on a case-by-case basis will keep on telling you the ingredients of basic structure. So there is a clear-cut correlation between basic structure and judicial review. Hence the question, what was held in the Yr Coelho case, and in that context, do you think judicial review is a key feature? Question number 3. This was a longer question, but was effectively very similar to the question asked in 2013. The question was, and listen to this carefully, the parliament's power to amend the constitution is a limited power, and it cannot be enlarged into an absolute power. That's exactly what the doctrine of basic structure says. Full stop. It basically means the parliament has a limited power to amend the constitution. That's all. Now, the second statement. In light of this statement, explain whether the parliament under 368 can destroy the basic structure by expanding its amending power. Statement number 1, the parliament's power to amend the constitution is a limited power. Why is it limited? It's limited because of the doctrine of basic structure. It is because of the doctrine of basic structure that the parliament cannot amend anything it wants to. So what if I remove that obstruction? Can the parliament remove the doctrine of basic structure? Therefore, it will have an unlimited power. So this question was on the impact of the doctrine of basic structure. Impact, or you can say the status of basic structure. Now, when you analyze these 3 questions in the mains exam, the 2019 question was asked in the context of abrogation of Article 370. It was asked in the context of the Citizenship Amendment Act of 2019. And 370 is correlated with Article 35A. When petitions were filed in the Supreme Court challenging the constitutionality of the abrogation of Article 370 or the constitutionality of the Citizenship Amendment Act of 2019, it was argued that it is a violation of basic structure, that the parliament cannot do this. Secularism is basic structure, so CAA is constitutionally invalid. Do we understand this? Simple enough? Yes. Similarly, federalism is basic structure, so you cannot take away Article 370 as far as we are concerned. But the primary argument that was raised was basic structure, which is why there was a question in 2019 on basic structure. Now, what is our analysis? What do we interpret from this? Number one, there will always be context to the question that is asked on basic structure. Number two, the history of basic structure is never asked. It is only for you to understand. In fact, you don't even have to remember the cycle of cases. What you just have to know is, what does it mean? What are the key legal issues? And how does it place in the Indian polity? That's all. So that's number two. Number three, you have to very clearly analyze the impact and the status of basic structure. So that is how we have to prepare the doctrine of basic structure. Now, linked to the doctrine of basic structure in the same evolution is also the doctrine of harmonious construction. Now, the doctrine of harmonious construction simply means a method to balance conflicting provisions. Now, you will generally see two kinds of conflicts in the Indian Constitution. One would be a conflict in the union list, state list, and concurrent list. This is a federal conflict. So the doctrine of harmonious construction would apply to this as well. And secondly, you will see the doctrine of harmonious construction to also apply to a conflict between fundamental rights and directive principles. To implement a directive principle, if a right has been taken away, is that okay? Is that not? What more can be done? Do we understand this? Simple enough? Yes, this is what we are dealing with. This is the context to it all. Now, how are we going to proceed with this? First things first, we will first understand the key legal provisions involved. Then we will set the context, and from the context we will start the journey, right? Okay. So our first set of legal provisions, Article 13, Clause 2. No law can violate a fundamental right. We are going to be using this extensively in understanding the doctrine of basic structure. Why? Because the meaning of law is going to be contested. The contestation is going to be whether constitutional amendments under Article 368 are law or not. The position today is they very much are not law. Are we clear on this? For the definition of law under 13.2, constitutional amendments are not law for the purposes of Article 13, Clause 2. Why? Because if constitutional amendments for the purposes, and this is only for the meaning of 13.2, they are law everywhere else. They are to be considered as enforceable everywhere else. But when we use the word law under 13.2, it does not mean constitutional amendments. Why? The answer to this is the same answer as to why judicial functions of higher judiciary is not state under Article 12. The answer to this is the same thing as we discussed yesterday, why writs cannot be issued to higher judiciary. The answer is the same. The concept is the same. Why? We've discussed this in Article 13. We've discussed this in class. Yes. If constitutional amendments were law, and as per 13(2), law cannot violate fundamental right, then a constitutional amendment can never change a fundamental right. It can never update a fundamental right. It can never downgrade a fundamental right. It would make the constitution a fossilized document. Yes? So this is why this is the first legal issue. Are we clear on this? Yes. So Article 13 Clause 2. Article 13 Clause 2 will have a direct conflict with Article 368. Article 368 is about the power of the Parliament to amend the Constitution. The original wordings of 368 was that it did not have the word power, it had the word procedure. We'll come to that later. But can anyone try and think and tell me the conflict, the simple conflict between 13(2) and 368? This is also a form of harmonious construction. Article 13 Clause 2 says, no law can violate fundamental rights. Power of the Parliament to amend the Constitution. The Constitution includes fundamental rights. So the Parliament will have to enact a constitutional amendment to change fundamental rights. So if law includes 368, then the Parliament's power is drastically reduced. Yes or no? If law includes Article 368, then the Parliament effectively does not have any power to amend fundamental rights. And if law does not include constitutional amendments, then the Parliament has the power to amend constitutional rights. Yes or no? Yes? This is the understanding. Article 13(2) says no law can violate fundamental rights. 368 says power of the Parliament to amend the Constitution. Constitution includes fundamental rights. So this could mean power of the Parliament to amend fundamental rights. You would do so by making a law, by a constitutional amendment, but technically you can't. So the actual legal conflict is between 13(2) and 368. This is the primary legal conflict. All right, are we clear on this? Now, apart from this, we have some fundamental rights that we are going to be talking about. First things first, Article 31. Okay, now Article 31 today has ABC, but we don't have to worry about ABC. We're looking at Article 31. Originally, Article 31 had your fundamental right to property. Plus, you had article 19 clause 1 clause F, which also related to the right to property. Are we clear? So these two fundamental rights guaranteed you the right to property. Do we understand this? Yes or no? Excellent. So 13(2), 368, Article 31 and 19(1)(f). You are primarily playing with these articles. On top of this, you have Article 32 and 226. Yes. What are they? Power to issue writs. Supreme Court and High Court. Correct. So these are the original provisions that we are playing with. These are the original legal issues that will come up over a period of time. So we are okay with this? Yes? Excellent. Now, let's start. Our first job is to establish some form of context. Why are we even discussing this? Why does it matter? Let's take an unrelated example. Let's take an example that none of us have ever spoken of. Okay? Are there any engineers in class today? Of course there would be. Correct. Excellent. Now, if you are an IT engineer, engineers here, anyone engineers? Engineer, good. If you are an IT engineer working, whether you have anything else or not, you will definitely have a company laptop or a computer or a machine. Yes? You will not have an office. You will not have human rights. You will you will not have any of those things. But you will always have a laptop. Now, if you take a step back and if you think this means that the occupation and the asset are equally distributed. Everybody who's engaged in this profession has access to that asset that makes you grow in this organization. The bare minimum requirement for you to perform your job as engineers is a laptop. That is correct? Yes. Now, correlate this to India's largest profession, India's biggest profession, India's most popular profession, and contrary to everybody, it is not engineering, it is agriculture. Yes? So what is the most important asset in agriculture? Land. This equation is not true for agriculture, right? So land, unlike a laptop, is unevenly distributed. Very few people have access to very large chunk of lands. Yes? And unlike a laptop or a factory, land can never be manufactured. Land can only be redistributed. Yes, that's the disadvantage. You cannot manufacture land. You can only redistribute land, because land is a finite commodity. Is it not? It's a finite commodity. There is no other option. Now, land inequality in India goes back centuries. we've always had land inequality in India. It became worse because of British policies, because Britishers had to appease the landowners so that they become cushioned, so that they are not a part of the resistance. And therefore, in a way, one could say zamindars flourished in the British era, and the British land revenue policies were extremely draconian. You would have heard of the Mansabdari system, the Rotwari system, the subsidiary alliance, yes, the lapse system, so many different things. Yes? So this means at any given point of time, this means land is always going to be a policy issue. And when India became independent, socialism was an extremely important ingredient of our DNA. Yes or no? Yes. We were deeply impressed by the Soviet, and we understood for a country like India, which has 200 years of foreigner rule, which has involuntary federal relations, the center comes before the state, which has extremely poor socio-economic indicators like literacy, which has extremely high ratios of diversity. For these 4 specific reasons, socialism became almost necessary for us. Yes or no? Almost necessary for us. And one of the first areas where the government would have to intervene would be land. Now the problem is, land cannot be manufactured. It can only be redistributed because it is finite. So therefore, land has to be distributed from X to Y by the government, which means the government will have to compulsorily buy land from X and then redistribute it to Y. X could be your zamindar and Y would be your landless laborer. If government has to compulsorily buy from X, then X has to compulsorily sell. Yes. How will you execute this? On what basis will you go up to a zamindar and say, I want your land? For that, you will have to create limits on land. Yes. You will have to create, because of socialism, ownership limits, or you could call it ceiling limits, that people cannot own more than an X amount of land. Make sense? How do we do this? Because there is another complication. The complication is, land is a state subject. This means you cannot have a national law on ownership ceiling. You cannot have a national land reforms act putting limits on the amount of land a person can own. This means states will have to do it. Thankfully for us, when we are becoming independent, you have the same political party in power at the center and also at most states. So if the Indian National Congress has won the national elections or is a dominant party at the center, it is already a dominant party at the states. Because if you quickly go back to our lecture on legal history, provincial elections were held before national elections. The Government of India Act of 1935 had effectively created a full responsible government at the level of the states, and the Congress has had a sweeping majority across these provincial assemblies. So most of these states already had Congress governments. Yes or no? Now you have the same leadership at the center. So you would request the center would request the states to make land reform laws. Yes or no? The states that have the same government. This is the earliest example of cooperative federalism. Think about it. The first independent example of cooperative federalism is land reforms. The center and the states worked together to create state-specific land reforms. Do we understand this? Are we okay with this? Yes? Excellent. So this means different states, UP, MP at that time, it was called Vindhya Bharat and all of those, Madras, Bombay at that time, different states enacted state-specific land reform acts. Yes or no? Now, these land reform acts put a limit on the quantity of land that you could own. This law is enacted by the states, and states come under the larger definition of Article 12. Yes, and you have Article 31 and Article 19 Clause 1 Clause F, which guarantee you the right to property. Fundamental rights are against the state. A state law is violating your fundamental right categorically. By doing this, they are treating zamindars and landless laborers differently. Yes, if a law discriminates people or treats people differently without a rational basis, it also violates Article 14. So now 14, 19(1)(f) and 31 are violated because of these state reform acts, right? If a law violates your fundamental rights, can you challenge that law? Yes, you can challenge that law in 32, you can challenge that law in 226. Now, several zamindars challenged that law in the different high courts. As a result of this, some high courts gave a positive response. They nullified some of the laws. Some high courts upheld some of the laws. Are we clear on this? Yes? Sure? Understood? Great. Because of this, it caused a lot of instability. You could not have uniform land reform laws. Yes? So what does the center do? The center says, fair enough, I am getting these irritations to these laws. These laws are being judicially reviewed. Yes or no? This process is the process of judicially review. Yes or no? What if I can stop this process? What if I can provide immunity to these laws from judicial review? So let me add a box to the constitution. How do we do that? I have Article 31. It says right to property. Let me add an exception to Article 31. 31A. 31A. Saying all those laws in the 9 schedule, all those laws in the 9 schedule cannot be judicially reviewed. अब बताओ. And why are you crying? Doesn't matter. Sarkar is here. I also added 31B. Saying I will give you compensation for it. यही है ना? बस. Constitutionally guaranteeing compensation. This was done through the first constitutional amendment, 1951. This is it. The story starts from here. So therefore, one of the most notorious and underrated, we often give a lot of gali to 42nd Amendment, but the real culprit is the First Amendment. वो आग के नीचे से सब करके चला गया. So, the first constitutional amendment of 1951, what does it do? It adds the 9 schedule which prevents judicial review. Yes, because this 9 schedule will contain a list of any law. It includes land reform laws. That's what happened. They created the 9 schedule and they added these laws to the 9 schedule. So whatever is in the 9 schedule now cannot be judicially challenged, cannot be judicially reviewed. Excellent. Do we understand this? Yes? Fantastic. This means, yes, to give a sense of affirmation that yes, we are taking land away from you, but it is not against your interest. I know you wanted to hold your land, but the prevailing price is a fair price we will give you. Later on they amended 31B and said we will give you fair market price for it. That happens later, that you will get compensation. Later they said fair market compensation to double down on it. But the idea is clear? Okay. So the first and the most important thing that the First Amendment did was it restricted judicial review. This is your prelims question from 2023. Clear? It has also done a lot of other things, very notoriously. For example, if there were land reforms, there would have been debates, there would have been protests around it. Yes or no? If you remember, Article 19 Clause 2 was also added by the very first amendment to the Constitution. It was not there before. It was added by the very first amendment. Yes or no? Clear? Excellent. So this is why the first constitutional amendment of 1951 has had multiple ramifications on multiple fronts. But what it is most popularly and most vigorously known for is judicial review. Do we understand this? Excellent. So now this is how the story starts. This is how the story starts. The story is, we now know the preface to the story. State Land Reform Acts, yes, they were challenged, In response to those, you had the first constitutional amendment. Excellent. So that was the first part. So the story actually starts with the first constitutional amendment of 1951. Are we clear on this? Yes. 1951, just to repeat this, added the following things. As far as property is concerned, it added 31A and 31B. 31A was a declaration that no fundamental right is violated on government acquisition. मतलब बात ही खत्म. If the government is acquiring your land, no fundamental right is violated. And 31B was the 9th schedule. Anything added to the 9th schedule will not be judicially reviewable. पहले तो declaration कि एक तो पहले ये सुन लो कि गवर्नमेंट अगर तुम्हारा लैंड ले भी रही है ना चचा, तो कोई फंडामेंटल राइट जा नहीं रही है. And if we are making a law, then that law is under the 9th schedule, then whatever is under the 9th schedule cannot be touched by the judiciary. होगी तुम्हारे पास fundamental right. A fundamental right that cannot be judicially reviewed is an incomplete fundamental right. That means you've compromised judicial review, you've compromised rule of law, you've compromised writ jurisdiction. In that order, yes or no? Good. So 31A, no law is violated, no fundamental right is violated if the government is acquiring your land. 31B, very simply, very clearly, anything in the 9th schedule is immune from judicial review. समझ में आया? Yes? ठीक. Now, several laws were added to the 9th schedule. Several state land reform acts were added. One of the zamindars was called Shankari Prasad. So your first case becomes Shankari Prasad versus Union of India, 1951. Usi saal. And you have to appreciate this, that we've not had our first Lok Sabha elections yet. The Constituent Assembly is the interim parliament. The people who drafted the constitution are the ones adding provisions limiting the constitution. जिन्होंने बनाया है वही exact same लोग इसको अब तोड़ रहे हैं. Are we clear on this? Yes? Because officially the first Lok Sabha elections happened in the year 1952. Fair enough. Now the Shankari Prasad case happens. For your exam, you just need to know the outcome of it. But to know the outcome of it, you have to know the arguments for it. Let's go through the arguments. ठीक है? So this is how it went. You are the Supreme Court. Shankari Prasad, Union of India. ठीक है? Shankari Prasad and Union of India. All right. So let's understand this as clearly as we can, as categorically as we can. ठीक है? Now, for 2 minutes, imagine you are Shankari Prasad and I am your lawyer. You have come crying to me. My land is being compulsorily taken away. I have to sell my land to the government. You are obviously very upset because land was the most potent form of prosperity back in the day. Even today it is. Land ownership is a strength of vitality. It's a show of prosperity. The one thing that you had was taken away. Yes or no? Do we understand this clearly? Excellent. So this means you've come to me and saying, Vakil Sahab, I am very upset. I didn't even want to sell it. But that district collector has come with a compulsory sale deal. I don't want to sell. Last I checked, I had a fundamental right. And I will tell you, you are right. You have a fundamental right to property. The law that the state government has made has violated your right to property. But the government, the constitution, the center has prevented me from challenging that law by putting that law under the 9th schedule. Then you say, Vakil Sahab, kuch to kar sakte hain. Kuch to hoga. If I cannot challenge what is inside the 9th schedule, can I challenge the 9th schedule? Yes. ये कैसे किया तू? 9th schedule कैसे बनाया? किसको पूछ के बनाया? Because the sheer insertion of the 9th schedule takes away the ability to question fundamental rights. Yes or no? The argument is a fundamental right needs to be judicially reviewed, otherwise it is pointless. Anything that takes away the judicial review of fundamental rights violates rule of law. Yes, and we are a rule of law country. So therefore, when I insert the 9th schedule, the 9th schedule itself is violating my fundamental right by not letting me question it. You're taking away not only my actual fundamental rights, you're also taking away 32. You're preventing me from coming to the court because of the 9th schedule. Yes or no? Now, the 9th schedule has been added by a constitutional amendment under 368. And this amendment under 368, the first constitutional amendment 1951, itself is violating fundamental rights. Yes or no? So, a constitutional amendment is violating fundamental rights. A constitutional amendment is legally enforceable. A law is violating fundamental rights. And Article 13 Clause 2 says, no law can violate fundamental rights. तो कहानी ये है. Understood? That means the 9th schedule itself is violating fundamental rights by being a law that is violating fundamental rights. So I will go to the Supreme Court on your behalf and say, my lord, the 9th schedule itself, doesn't matter what is in it. What is in it is even worse. But the fact that you could even have the 9th schedule that compromises my fundamental rights is a violation of Article 13 Clause 2. Yes or no? Yes. It is a violation of 13 Clause 2. Correct? Supreme Court is like, wow, क्या बात है, क्या ही कहा है, माशाल्लाह. Who is the highest law officer of the central government? Attorney General. Yes. So AG Sahab will come, AG Sahab will argue, and AG Sahab will be like, my lords, 1 second, hold on. Now I am the AG. You are the Supreme Court. My lord, This constitutional amendment, which is the first amendment of 1951, my lord, has been enacted by the parliament under powers of the parliament under 368. This is not an ordinary power, my lords. This power is called a constituent power, my lord. This constituent power has been transferred from the Constituent Assembly to the Parliament, my lord. We have the power to do this. Don't equate a constitutional amendment with a random law made under the 7th schedule. A law made by the Parliament under the 7th schedule, which is under the union list or the concurrent list, that, my lord, is an ordinary power. So when you say no law can violate a constitutional, can violate a fundamental right, my lord, this law refers to ordinary power. My lord, it doesn't refer to constituent power. It cannot, my lord. Because if constitutional amendments were law, then my constitution becomes a frozen document, my lord. It goes against the vision of the makers of our constitution, my lord. So it is therefore prayed before you, my lord. Don't think about it in such a narrow way that Shankari Prasad and his lawyer are. Constitutional amendments are exercise of constituent powers. They are also laws, but extraordinary laws. Because you are not amending any random law. You are amending the supreme law. The power to amend that supreme law is directly from Article 368. Don't equate it to be like any other law, my lord. This is a super law. A super duper law. Don't think of it as anything else. When we say no law can violate a fundamental right, we mean ordinary laws. Union list, concurrent list, order, ordinance, that, my lord. Tuchha laws. Not a supreme law. That cannot be law. Shankari Prasad agreed. Oh, wow. Now, you're determining the constitutionality of something? Yes or no? So you would require a minimum of 5 judges. And you will generally see a 3:2 judgment. Now, some of you will agree with him. Most of you will agree with him. So the judgment will be 3:2. Majority. So the Supreme Court in Shankari Prasad case identified that there are constituent powers and ordinary powers. Ordinary powers can be law under Article 13 Clause 2. But constituent powers given to the Parliament under Article 368 are not law as per 13 Clause 2. And therefore, the Parliament can make any change, good, bad, right, wrong, to fundamental rights. Yahi kaha na? Bas. Understood this? Yes. So in round 1, the government won. Who won? Government. Now if you win, aisa chhati bhadta hai na? Feel very happy, overconfident. Are we clear on this? Excellent. And whenever you are overconfident, you will make a mistake. You will make a mistake. So what happens is, In 1964, they have the 17th Constitutional Amendment. 1964. Are we clear on this? Yes. And through this, they add so many more laws to the 9th schedule. Up to Aardhi. Aardhi. Bar. And the two states that they added, और यही दो पे पंगा होना है, one was Rajasthan, the other was Punjab. So a zamindar from Rajasthan, Sajjan Singh, had the same issue. So Sajjan Singh versus state of Rajasthan. ठीक है, 1964. Sajjan Singh versus state of Rajasthan. 65 actually. Judgment was reported in 65. The exact same thing. The exact same argument. Sorry? एक तो raise your hands. Secondly, what? Sorry? The state of Rajasthan. क्या आएगी? The center did. The parliament enacted the 17th constitutional amendment and added the laws that were passed by Rajasthan and Punjab to this list. They have the powers to add anything. They added the laws made by the state governments to the 9th schedule. Why can't they? They have not passed these laws. They have added these laws to the 9th schedule. Rajasthan Assembly, Punjab Assembly passed the respective land reform acts. The parliament just added them to the 9th schedule. Are we clear on this? Okay. Hence, Sajjan Singh versus state of Rajasthan. Right? Now here, the mild discussion was the procedure through which these were added. It was questioned whether it would require state ratification or not. It was discussed whether it's a federal impact or not. But the judgment was exactly the same. The judgment was exactly the same. They had 5 judges here. Now they will have 7 judges. Here 3:2. Here 4:3. ठीक है? बस अब यही नहीं करना था. ठीक है? Because Punjab Super Kings, what is that team called? Kings 11 are left. You do not mess with them, Punjabis. So, a case happens. And this case is none other than Golak Nath versus state of Punjab. I see Golak Nath versus state of Punjab, Golak Nath versus state of Punjab. In your answers, both are acceptable. Golak Nath versus state of Punjab, 1967. ठीक है? Now, are we okay with this? Same thing. Instead of Shankari, Golku. ठीक है, they're my buddies. Instead of Shankari Prasad, Golak Nath. ठीक है? Same arguments. Everything is the same. Not in your syllabus, but a little bit of legal history. The first time, what are you discussing? What is the larger idea behind all of this? When you are discussing Golak Nath or any case versus the state of Punjab, what are you effectively discussing? You're discussing that Schedule 9 has been added to the Constitution, which effectively means the Constitution has been changed, and changed in a manner that there is a reduction of fundamental rights and there is a reduction of judicial review. This is the legal question. Can the Constitution be amended? Does the Parliament have unlimited powers to amend the Constitution? Because Article 368 originally said procedure to amend the Constitution. It did not say power. Are we clear on this? Do we understand this? So the big legal issue is now this. The same arguments. Ordinary power, constituent power, everything. But this time, Golku judges were a little crazy. Supreme Court was a little cray-cray. वो बोले उतना ही पैशन से अटॉर्नी जनरल साहब, उतना ही पैशन से, my lords, hey my lords, hey my lords, ordinary power, constituent power, my lords, ordinary power under 368, my lords. Supreme Court बोला इतना इतना इतना, एक सेकेंड तुम्हारा समझा. What is ordinary power? Sir, power under Schedule 7. Okay. What is constituent power? Sir, power to amend the Constitution. How do you have constituent power? Sir, Article 368. He said, पढ़ना एक बार. Please पढ़. एक बार. Please, sir. Please. Little you read, no. Article 368 originally read, procedure to amend the Constitution. Oh. ये जो पावर बोल के ऐसा चाहती पीटा, पावर तो है ही नहीं, प्रोसीजर है. चल कोई बात, नो प्रॉब्लम. तेरे को ये प्रोसीजर कौन दिया? मैं दिया? नहीं. Who gave you the power? Who gave you the procedure to amend the Constitution? Sir, I am the Parliament, my lord. If I not, then who? If not me, then who? Sir, Constituent Assembly transferred their power to me. बोले किधर लिखा है? Constituent Assembly gave you that power. You have assumed that power. Did anybody give you that power? No, my lord. Is there any law made by the Constituent Assembly, any order, anything in the Constituent Assembly, anything that says that the powers will lie with the Parliament? क्या हमारी घर की चाबियां तुम्हारे पास? ध्यान रखना हमारा. Was there some transfer? No, my lord. तो तू कैसे बोला? How do you have power? Sir, assume, sir. After Constituent Assembly, I am the biggest democratic house. No, that you are. But who gave you the power? Sorry, my lord. गोलकू बोला यही तो मैं कहना चाह रहा था सर. Exactly, sir. देख समझाओ इसको. So in the judgment of Golak Nath versus State of Punjab, the Supreme Court overruled everything else. Everything. They said, ठीक है. First things first, constitutional amendments are law under Article 13 Clause 2. There is no difference between ordinary power and constituent power. None. Because nobody has given you constituent power. You have assumed that you have constituent power. Nobody gave you constituent power. You have assumed that you have constituent power. Do we understand this? Yes. So, it is exactly the same thing. Which means, if constitutional amendments are law under 13(2), that means you cannot amend the constitution at all. Specifically part 3. Because no law can violate part 3. So nobody can touch fundamental rights. They were meant to be part 3 for a reason. Change whatever in the constitution you want to. I'm not saying anything. Don't touch part 3. Yes or no? जो करना है करो. Don't touch part 3. It is sacrosanct. It is above everything else in the constitution. Don't touch it at all. Are we clear? So now, constitutional amendments are law. The power of the parliament has been severely restricted. They can make any change to the constitution, but they cannot touch fundamental rights. Are we clear on this? Understood? Yes? ठीक. इसका मतलब Golku will get his land? इतना मेहनत किया. And Golak Nath, this is 5-7, Golak Nath is 9. So the judgment is 5:4. ठीक है. अभी इसके बाद 9 से सीधा 13 जंप होता है. रुक जा. ठीक है. Now, this judgment has to be delivered in 2 parts, which is why from 9 it upgrades to 12. From 9 it upgrades to 11. Now, there's a reason behind it. Everything has been discussed except Golak Nath's acceptance of land, which is why a higher bench was set up. 11, 6:5, and the Supreme Court adopted the American principle of prospective application. Matlab, judgments will only be applicable from a current to future date. Judgments can never be retrospectively applicable. So that is why the initial 9 judge was upgraded to a 11 judge. And that is why you had 6:5. Because you had to apply the American doctrine of prospective overruling. And this is a very important doctrine. Under Article 20 we have studied criminal law cannot be applied retrospectively, but civil law can be applied retrospectively. Any judgment cannot be applied retrospectively. Yes or no? But then law and judgment become confusing, because technically judgment is a type of law. Yes or no? So doctrine of prospective overruling is applied on a case-to-case basis. In civil cases, sometimes you can get predated relief. For example, in administrative cases, your promotion was due 2 years ago, so your arrears will come from 2 years ago. All of those things. Okay? So because of the doctrine of prospective overruling, Kesavananda did not, Golak Nath did not get his land back. यहाँ तक समझ में आया? Yes or no? All right. अब इंटरवल हो गया है. अब इंटरवल हो गया है. ठीक है? ठीक है. ये कहानी चल रही है. इंटरवल हो गया है. अब एक दूसरा कहानी यहां से धीरे 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 आके इधर मिलेगा. एक दूसरा कहानी. वो कहानी यहीं आएगा, यहीं जुड़ेगा. But it's a very important story because this story is about amenability of fundamental rights and amenability of the Constitution. This leads to the doctrine of basic structure. The second story is the relationship between fundamental rights and directive principles. This story will also come and meet here. The story starts in 1951 with a case that I have already spoken to you about, Champakam Dorairajan versus State of Madras. Madras. Tamil Nadu was not there at that time. Madras. So, this is the case. Champakam's case. Champakam Dorairajan versus State of Madras. Champakam Dorairajan versus State of Madras. Let's understand Champakam Dorairajan as clearly as we could. If you remember, it was India's first ever reservation case where the State of Madras had implemented a certain type of quota. This is 1951. 15.5, 15.6, 15.4, none of them existed. Article 15 ended at 15.3. The last provision of Article 15 was 15 clause 3, which was special provisions, very good for women and children. Understood? So therefore, when Champakam Dorairajan was argued in the Supreme Court, what did Champakam say? What did Champakam's lawyer say? Champakam's lawyer said, my lord, there is nothing in the Constitution that allows the State of Madras to provide for such quotas. There is nothing in the Constitution that gives you the permission to provide for such quotas in education. The story stops at 15 clause 3, my lords. There cannot be any quota, my lords. It is a violation of my fundamental right. What did the State of Madras say? State of Madras said, my lords, I am not doing this for fundamental rights. I am doing this to make society as a whole better. I am doing this for directive principles. My directive principles, such as creating a better society, equality, prevention of concentration of wealth, access to opportunities, providing a good standard of life. My directive principles allow me to do this. I am just doing what the same Constitution directs me to do. I am implementing the larger vision for this country, my lords. My lords का आंख से आंसू आ कि ओहो क्या स्पीच है अटॉर्नी जनरल. अब वहां तो एडवोकेट जनरल हुआ ना, बट अटॉर्नी जनरल बिकॉज केस, हाँ एडवोकेट जनरल, इवन इफ इट्स इन द सुप्रीम कोर्ट. क्लियर ऑन दिस? यस. Judge bola, I am very touched, but no law can violate a fundamental right. Article 13 clause 2. Simple. No law can violate a fundamental right. This is an ordinary law. So therefore, fundamental rights are superior to directive principles. आया समझ में? By striking down the reservation policy, fundamental rights are superior to directive principles. Are we clear on this? Yes? Excellent. Now, the second case is also something you are very familiar with. We've discussed this in 29 and 30. We've discussed this before also. In reference, Kerala Higher Education Bill 1957. किया था ना 29-30 में discuss? The same thing. This is about, it was about minority, religious minority institutions. This is also the same thing. So, in reference, the Kerala Higher Education Bill 1957. 1957. Now, let's understand what this case is. We've discussed this before. The government of Kerala wanted to implement a certain set of quotas. Yes or no? A certain set of quotas in higher education institutions in Kerala. The year is 1957. Now, after Champakam, do you remember? They put Article 15 Clause 4. First constitutional amendment. Article 15 Clause 4. This was also added. This was also added. Article 15 Clause 4. Which means you can make any provision for the advancement of socially educationally backward castes, scheduled castes and scheduled tribes. Aaya samajh mein? Yes. This was in response to the Champakam case. And it said the state can make any provisions, which means center and state both. So therefore, what effectively happens is the government of Kerala makes a state law implementing all of this. Clear? It is still violating a fundamental right of equality. Equality before law. Because Article 15(4) just said you can make any provision. It did not specify provisions with respect to education. It did not. 15(5) and 15(6) come much later. Yes? Here the Supreme Court tries to balance the two and says, understood, directive principles command you to do something bigger for society. That was also what was happening. Yes or no? Directive principles command you to do something for society. Agreed. Very happy to. But fundamental rights cannot be compromised. Absolutely unacceptable for fundamental rights to be compromised. Are we okay with this? Yes. So in the Kerala higher education case, again, fundamental rights over directive principles, but try to balance them both. Supreme Court बोला लड़ किस ले रहे हो? Fundamental rights are for the people. Directive principles are for the betterment of society, which is of the people. So basically, implement uniform civil code in a way it does not violate secularism. यही मतलब हुआ? Balance rights and directive principles. The birthplace of the doctrine of harmonious construction. tried to balance both provisions. Yes, fundamental rights tell you don't discriminate against anyone. But directive principles tell you special provisions can be made for making society better. Balance the two. It should not be anti-egalitarian. Are we clear on this? Yes. So story continued. Happily, no problem. Fundamental rights chal raha hai, no issues. Then Golak Nath happened. Golak Nath was a roadblock to the government. The government could not do anything to violate a fundamental right. Yes? Yes or no? Bas. And this is 1967. Somebody has come into power. Somebody will come into power. The Prime Minister of India is going to be Srimati Indira Gandhi. So after Golak Nath, you will see a series of amendments. Thak, 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 thak. 24th Amendment 1971, 25th Amendment 1971 and 29th Amendment. The two major amendments, the three major amendments that you need to know are 1971. 24th, 25th and 29th. 24th, 25th and 29th. All of these are 1971. Clear? Remember judgment amendment in reservation? They gave a judgment, we made an amendment, they gave an amendment, wo chalta raha, same thing. What does Golak Nath tell you in one line? Constitutional amendments are law. Baat khatam? Yes? Pakka? 24th Amendment says the exact opposite. कहता बेटा, constitutional amendments are law, are not law under Article 13 Clause 2. Directly overruling Golak Nath. Directly. Golak Nath said constitutional amendments are law. That means you cannot touch fundamental rights. 24th Amendment said constitutional amendments are not law. A direct contradiction to the Golak Nath judgment. How did they do this? They added Article 13 Clause 4. आज भी है, constitutional amendments are not law. And just to be on the safer side, they added it in 368 also, that it is not subject to 13 Clause 2. Are we clear? Directly overruling Golak Nath. Aaya samajh mein? Yes? Good. That was the 24th Amendment, which meant now you can do whatever you want to. Again, the power of the Parliament to amend the Constitution has now become significantly higher. Yes or no? Yes. Significantly higher. You are back to your old days. You are back to your old habits. Yes or no? Excellent. And the 25th Amendment attacked directive principles. Attacked directive principles. The 25th Amendment added Article 31C. Article 31C. क्या लिखा है इसमें? Two directive principles of state policy are bigger than two fundamental rights, which are three actually. 39B, 39C are greater than 14, 19 and 31. Now appreciate the master stroke. 39B and 39C tell you two things in directive principles: prevention of concentration of wealth and distribution of resources. Which is India's most coveted asset? We just discussed land. So if you redistribute land, are you preventing concentration of wealth? Yes. Are you providing for distribution of resources? Yes. So if not through rights, मैं land से ये करूँगा, मैं DPSP से ये करूँगा. So my land reforms are actually under 39B and 39C. And if I'm implementing anything under 39B and C, this anything would be land reforms. Yes or no? Then my land reforms are greater than 14, 19 and 31. Kahani hi khatam. Yes or no? What a master stroke. But think about why they came up with the DPSP route. Between 67 and 71, something would have happened. Something would have happened. The government would have undergone a massive nationalization spree. Yes. Banks were nationalized. Privy pursers were abolished. That nationalization was challenged in the Supreme Court, R.C. Cooper's case. Supreme Court said, "ठीक है, this is all right, but don't do it again, it is illegal otherwise." The Supreme Court overturned privy purses. Nationalization is nothing but implementation of DPSP. Nationalization is socialism. Socialism is DPSP. Nationalization is DPSP. Yes. So they were constantly getting hits from the Supreme Court. So they said, let me block this DPSP also. Let my two directive principles, my strongest directive principles, the most vague directive principles, be more powerful than the three most hot contested rights, 14, 19 and 31. Okay? And not just this, if I do anything here, this will not be judicially reviewable. Any action of the government to implement a directive principle under 39B and 39C shall not be judicially reviewable. Do we understand this? Yes. Excellent. That is the process. Clear? Good. And the 29th Amendment added Kerala land reform laws to the 9th schedule. The Kerala land reform laws to the 9th schedule. अब आपको पता है क्या होने वाला है? वो आने वाला है. वो आ गया. Keshu. In 1973, the Kesavananda Bharati versus State of Kerala judgment. There were 11 judges there, 13 judges here, 7:6. Kesavananda Bharati versus State of Kerala, 1973. So what are you now battling with? You have a few decisions that have been made. Decision number 1, constitutional amendments are not law. Yes or no? Decision number 2, decision number 2, 39B and 39C are stronger than 14, 19 and 31. यही है ना मेजर? Yes? Good. Kesavananda Bharati upheld the fact that the constitutional amendments are not law. It overruled Golak Nath on this matter. All right? Now, Kesavananda Bharati upheld that constitutional amendments are not law. It upheld the 24th Amendment. It overruled Golak Nath when Golak Nath had said constitutional amendments are law. Right? Now the judges sat back and now they started discussing. One of the greatest lawyers who have walked this earth, is this planet, this country, Nani Palkhiwala. A brilliant commercial lawyer and also later on a great constitutional lawyer. Nani Palkhiwala had also argued in Golak Nath. And the idea of basic structure for the first time was spoken in Golak Nath. Now you have to listen to everything that I am going to say next. This is very important. All of this is a larger issue of how much can the constitution be changed and to what degree and who can change it, right? So when you have to discuss the doctrine of basic structure, what you are effectively discussing is very simply the extent and the intensity with which you can amend the constitution. This is called the theory of implied limitation. If the constitution is the supreme law, then changes to the supreme law have to be very careful. Because if you bend the supreme law in your favor, if you twist the supreme law in your favor, then it will no longer be worthy of calling itself a supreme law. Now, the story began with the power of the parliament to amend the constitution. Which means, my first question is, who can amend the constitution? The answer is, the parliament can. Are we okay with this? Yes? Excellent. My second question is, to what extent can the parliament amend the constitution? This is where the Supreme Court came up with the doctrine of basic structure. A set of principles. These principles will be evolved over a period of time. Some in this case, some in the next case, some till the end of eternity. These are not articles. These are principles. Secularism is basic structure. Can the parliament amend Article 25? Yes. In a way, it does not violate secularism. Judicial independence is basic structure. So can I change the way judges are appointed? Yes. But not in a way it compromises judicial independence. These are principles. These are not articles. All of this is to create a limitation on the change to the constitution, to uphold rule of law. Because if the constitution loses its essence, constitutionalism loses its essence. And if constitutionalism loses its essence, rule of law loses its essence. Do we understand this? So a set of principles can be the basic structure. Do we understand this? This is the outcome of the Kesavananda Bharati case. Now what was unique about the Kesavananda Bharati case was that under these Kerala land reform laws, Hindus are a religious minority in Kerala, and Kesavananda was the head of a mutt in Kerala, the Edgar mutt. So land by the Edgar mutt was property of a religious minority in Kerala. So not only are 14, 19 and 31 involved, 29 and 30 are also involved, because it is about protection of religious and linguistic minorities. Understood? So the case became larger than it was. And therefore, when the 13 judges sat, they had a larger discussion, a more open-ended discussion about the future of how much can the constitution be changed. The answer is basic structure. Then you get into the specifics of it. You are here before a court of law. What happens? Some principles of the constitution cannot be changed. Are we okay with this? Judicial review is one of those principles. Are we okay with this? Which means anything that takes away judicial review can be declared unconstitutional. Yes or no? Anything that can be declared, anything that violates judicial review can be declared unconstitutional. Yes or no? We applied an American doctrine in Golak Nath. What is that doctrine called? Prospective overruling, which means the judgment is going to be applied from now itself. Yes? So put all of this together. According to Kesavananda Bharati, basic structure of the constitution should not be violated. Judicial review is basic structure. And from April 1973, 24th April, that's the date of the judgment. From 24th April 1973, anything which is added to the 9th schedule is judicially reviewable if it violates basic structure. Not before. Why not before? Doctrine of prospective overruling. And the 25th Amendment, which said 39B and C greater than 14/1931, and such an action cannot be judicially reviewed. Everything is okay. Take the judicial review part out. So yes, 39B and C are still greater than 14/1931. It's just that we can judicially review that action. Understood this? Yes. Excellent. The very first application of Kesavananda Bharati's case is actually a political application. The political application is the case of Indira Gandhi's emergency election case. So if I just extend this time, देखो कैसे होता है. अरे ये क्या हो गया? Oh, thank God. If I just extend this and I say, my story is here. I have reached 1973. In 1973, what are my decisions? Constitutional amendments are not law as per Article 13, Clause 2. Any doubt? No. 39B and 39C are greater than 14, 19 and 31. But this can be judicially reviewed. And any changes to the 9th schedule after April 1973 can also be judicially reviewed if they violate basic structure, because you have come up with something called the doctrine of basic structure. ठीक है? The first application of this law, the first application of the doctrine of basic structure. By the way, basic judicial review as identified as basic structure was discussed in Kesavananda, but was not accurately defined in Kesavananda. It was in Sampath Kumar's case much later that was said so. But anyways, do we understand this so far? सबको समझ में आया? ठीक है. So the first application was the Indira Gandhi election case. The first application was the Indira Gandhi election case. Yes. Indira Gandhi versus Raj Narayan. Now what is this case? What basically happened was that Indira Gandhi's election to the Prime Minister, to the Lok Sabha, and eventually to be selected as the Prime Minister, was declared invalid by the Allahabad High Court because she was found to be guilty of misusing government machinery for electoral purposes, which is a violation of the Representation of People's Act of 1951. Are we okay with this? Do we understand this? Excellent. So therefore, Allahabad High Court in this case declared her candidature to be invalid. If you're not an MP, you cannot be the PM. Simple as that. She went on appeal to the Supreme Court. So the case became Indira Gandhi versus Raj Narayan instead of Raj Narayan versus Indira Gandhi. Do we understand this? Are we clear with this? Now, at that moment you were not there, na? So you have been debarred, you've been disqualified. So then you have to be reappointed as the Prime Minister, and then you have 6 months. Anyways, कभी भी question आए तो 2 मिनट खुद सोचो, जवाब नहीं मिले फिर पूछो. I'll come to your question in 2 minutes. ठीक है? Now, all okay? The case reaches an appeal to the Supreme Court. Supreme Court poses a stay. ठीक, we'll discuss this. Overnight national emergency. And you pass a constitutional amendment. And that amendment says the election to the Prime Minister, election to the President, election to the Vice President is not under judicial review. The Supreme Court invalidated that amendment and said democracy is basic structure. If I cannot question the Prime Minister's election, I am not in a democracy. Do we understand this? Now peak emergency, heavy socialization, you bring in a very, very naughty constitutional amendment. 42nd Amendment 1976. Oh yeah. Naughty. From 2 DPSPs superior to 3 fundamental rights, they said all DPSPs superior to 14, 19 and 31. Okay? And they brought back again no judicial review because it was still not officially declared that judicial review is basic structure. Do we understand this? Yes? Okay. They also tried here to reverse Kesavananda by 368, saying nothing applies to 368. Powers under 368 are therefore not applicable to 13 clause 2. ठीक है? 2 साल बाद government बदली, 42nd Amendment 1978, right? तब तक basic structure was almost declared. So they said all DPSPs bigger than 14, 19, 31, but ये judicial review कर लो, हमें कोई प्रॉब्लम नहीं, हम अच्छा ही काम कर रहे हैं, नई सरकार है, हम अच्छे लोग हैं, कर लो, ठीक है. Except for one thing, this entire story starts and ends with the right to property. They remove right to property as a fundamental right. So now it becomes all DPSPs bigger than 14 and 90. This gives the government a free hand for socialistic policies. And in exercise of these socialistic policies, this is what they do. They nationalize a textile mill in Karnataka. The name of the textile mill is Minerva Mills. So the case happens as Minerva Mills versus Union of India. Now this is the last attempt, the most underrated and a forgotten case, the last attempt to destroy basic structure. So ye jo they tried to reverse this at 42nd Amendment was reinstated. So constitutional amendments are not law under 13 clause 2, which means you can amend anything in the constitution. Doctrine of basic structure will apply. 39B and 39C will be greater than 14 and 19. And all of this is subject to judicial review. Are we clear on this? Yes. And anything added to the 9th schedule after Kesavananda Bharati's case is judicially reviewable if it violates basic structure. Are we okay with this? Are we fine with this? Yes or no? Okay. Excellent. And then finally, there were two cases in the middle. One is a very small case called Vaman Rao, and the other is the more important case, Yr Coelho versus Tamil Nadu in 2006. 2006. Okay. Anyways, let's continue. Delivered in 2006, judgment reported in 2007. ठीक है, पढ़ के आते हैं, थोड़ी तो इज्जत रख ले. ठीक है. Delivered in 2006, judgment reported in 2007, which is why 10 years later you have a case in UPSC about what was held in the Yr Coelho case. बोलते हुए मत काट. ठीक है. Are we okay with this? ठीक है. In Yr Coelho versus State of Tamil Nadu, this is the Tamil Nadu reservation case. What Tamil Nadu did was, remember Indra Sawhney? Yes, Baba? Indra Sawhney says you cannot have reservation more than 50%. Tamil Nadu has given reservation in a way it is more than 50%. In fact, it is 69%. But that Tamil Nadu reservation law is in the 9th schedule. So you cannot touch it. Why? Because it is in the 9th schedule before 1973. So in Yr Coelho versus State of Tamil Nadu, what did the Supreme Court decide? What did the Supreme Court say? Anything in the 9th schedule can be judicially reviewed as long as it violates basic structure. So then why did you not challenge Tamil Nadu reservation? Because reservation is not basic structure. So you cannot challenge reservation. Reservation cannot be a basic structure because reservation is not a right. It's a privilege. and it has been said so multiply by several judgments of the Supreme Court. Do we understand this? तो कहानी कहां से शुरू हुई और कहां खत्म हुई? Understood? Good. So this means this entire ecosystem essentially dealt with three basic problems. The first, the basic structure doctrine. Second, the limitations on the amending power of the constitution by the parliament. And third, the essential features of the constitution. This is what the judgment is about. Now, which brings me, just give me a second. Sir, आज क्लास नहीं है? कितने बजे? Okay, ठीक है. So this means, what does this judgment lead to? What is its impact? The basic structure judgment has the following key advantages. One, it ushers in an era of judicial review and constitutional supremacy. Nothing comes close. See, you must understand, all of this is as interrelated as rule of law. The doctrine of basic structure takes center stage, and anything which are the essential features of the constitution automatically become the doctrine of basic structure, whether it is judicial review, whether it is essence of federalism, whether it is parliamentary democracy, whether it is judicial independence. And all issues out of these are issues of basic structure. Are we clear on this? Do we understand this? So the the basic structure doctrine fundamentally ushers in an era of what is called constitutional supremacy. Second, it helps a great deal in protecting fundamental rights. Third, because of basic structure, you are now able to maintain some form of fairness in federalism. Yes or no? So any coercive federal action, SR Bomai's case, would only have happened because of the basic structure doctrine. The unlawful or the questionable imposition of emergency, questionable imposition of GST council powers, interstate water disputes. You could now challenge everything on grounds of federalism. So the impact of basic structure are essentially the essential features of the constitution. Do we understand this? And it therefore has severely limited our constitutional amendments. Think about it. We've had 40, we had close to 40 amendments till 1973. Just in the first 20 years, we've had close to 40-45 amendments. And after that, the frequency of constitutional amendments has drastically reduced, because you cannot amend the basic structure, a set of principles. This could have only happened because of basic structure. So not only has it provided a degree of consistency, a degree of stability, it has also ensured in the evolution of the constitution. As and when you add more and more features to the basic structure, you tend to give more and more dimensions to the constitution. So when you say judicial review is basic structure, that would therefore apply to the constitutional issues of tribunals. Yes or no? Today tribunals are a constitutional issue because any change in the power of tribunals is a change of judicial review, is a change of judicial independence, which is basic structure. So they will have their own set of judgments. Understood? But it's all not that great. It's all not that fair. My larger issue is, it is still 13 appointed judges. The Kesavananda Bharati judgment is one of the lengthiest judgments written in South Asian history. It extends to, I think, about easily 4 lakh words across 800 pages. It has the maximum number of separate opinions delivered by the 13 judges. It is one of those rarest judgments in the Constitution, about the Constitution, where an official summary of the judgments had to be declared. And a few judges even refused to sign it. And when you are appointed, and look at the narrow margin, 7:6. All constitutional cases in India of this nature have always been by a margin of 1. 3:2, 3:2, then that's 5, 7, 4:3, then 11, 6:5. Golak Nath was 6:5. Sajjan Singh was 4:3. Shankari Prasad was 3:2. All of these cases have been a factor of 1. So a difference of 1 judge changed the constitutional future of this country. Is this justified? No. And till today, there is no clarity on what is absolutely basic structure. What really is basic structure? Because it is such a big judgment. It is like interpreting 13 different judgments. And this judgment came at a point of time where we had very, very anxious political circumstances, if you think about it. We were in an emergency era, stepping into it. We were seeing a hostile political neighborhood. There is absolutely no reference to basic structure in Constituent Assembly debates. It is an idea that we have taken from the German Constitution. Yes. The Weimar Constitution, the German Constitution. The idea of basic structure. Randomly dropped by Nani Palkiwala in the Golak Nath judgment. And fundamentally, it creates what is called an intra-constitutional hierarchy. Because the answer is very clear. You can change anything in the Constitution as long as it doesn't violate basic structure, and we, the Supreme Court, will tell you what is basic structure. So directly or indirectly, you've twisted the era into an era of judicial supremacy. Are we clear on this? Yes. Because the Germans are very clear. If the parliament can't amend the constitution of a country, nobody can. And your way forward would be, whether it is basic structure or anything else, the answer lies in constitutionalism, nothing else. Even through basic structure, you are limiting the powers of the state. Understood? So through different judgments, different outcomes, different entities of basic structure have been identified. Are we clear? So going back to our original discussion, these were the mains questions, these were the prelims questions. With this, we should be able to answer all. है ना? ऐसे. Are we clear on this? ठीक. So on one hand, constitutionalism, hierarchy, stability. On the other hand, undemocratic judicial supremacy. That, ladies and gentlemen, is basic structure for you, with a little bit of harmonious construction. Chalo, let's wind up. They have a class. Thank you. Good afternoon, everyone. Good afternoon. So we have one clear agenda today to close theme number 3. Now we've got 3 things to do for our closure. First, the analysis of the basic structure doctrine that we briefly discussed yesterday. What kind of questions can come from here in the mains? 2, an analysis of fundamental duties and directive principles, in which why do we need them, what have their roles been, what is the role of the judiciary, how can we make them better. Answers to these questions must be prepared. And finally, we will do a live PYQ solving like how we have done for every theme up until now. These are the 3 things. So we will divide it into 2 lectures. One, we'll finish basic structure analysis, then we will pick up directive principles and duties, and then PYQ solve. Sorry for yesterday, I have a sprain in my back, so I could not, I came, took a morning class, and then the pain got so severe, I had to go home, which is why we had to not take the class yesterday. उम्र हो गई है, आया ना, लेकिन जवानी जा नहीं रही है. प्रॉब्लम यही है. चलो, theme 3, preamble, fundamental rights, directive principles of state policy and fundamental duties. Topic 4, the doctrine of basic structure and the doctrine of harmonious construction, part 2. We had broadly discussed the kind of questions the UPSC has asked from here in the mains. So when we have to prepare this for the mains, what are the 3 layers that we have to prepare? We broadly have to answer first the significance of it, second we have to answer the impact of it, and third we have to answer the future of it, the outcome of it. What can happen from here? Can basic structure be removed? If so, how? So the final outcome of it, or maybe the prognosis of it. What we have understood so far in simple terms is the Constitution always gave the powers of judicial review, and these powers of judicial review were indirectly derived from various provisions of the Constitution, starting with Article 13(2), then 32, then 226, then Schedule 7, 246, so on and so forth. The word judicial review has never ever been explicitly mentioned anywhere in the Constitution. And the doctrine of basic structure basically gave wings to judicial review. So my first question to you is, why is this significant? Why is this important? Why are we even discussing this? It's not about what is the good part or the bad part of it, but when you have the doctrine of basic structure, what does it signify? What is it trying to project? Yes, anyone? Okay. So those are the things that it has upheld. Great. So you can mention basic things such as the spirit of constitutionalism, Second, the spirit of rule of law. Now, one by one, tell me the relationship between constitutionalism and the doctrine of basic structure. What is the relationship? One, raise your hands, please. Yes. Yes, that is rule of law. Constitutionalism. Okay, very good. Yes. So constitutionalism in one line simply means limiting the powers of the state. So anything which limits the powers of the state effectively is constitutionalism. Through the doctrine of basic structure, you're limiting the powers of the parliament to amend the constitution. So therefore, upholding certain principles of the constitution. The principles of basic structure are derived from the constitution itself. And when you are giving a sense of immunity to those principles, supremacy to those principles, you are effectively trying to protect those principles from any form of state intervention. And by doing this, you are promoting or propagating constitutionalism. If constitutionalism is restricting the powers of the state includes the parliament. By restricting the powers of the parliament to amend the constitution, by upholding certain principles of the constitution as supreme, as over and above everything, you are promoting and propagating constitutionalism. Do we understand this? This is a pre-question also, this is a mains question also. The second part, as you were saying, what is the relationship between the doctrine of basic structure and rule of law? Go ahead. Okay. Okay. What are the three basic principles of rule of law? Absence of arbitrary power, equality before law, and predominance of legal spirit. Out of the three, doctrine of basic structure fundamentally attacks two, fundamentally correlates with two. Now tell me the relationship between basic structure and absence of arbitrary power. Think about it. We have a long class today. Tell me. Something more basic. Very good. Something even more basic. Where is the arbitrary power? Where? What is the power? Article 368 gives an open-ended power to the parliament to amend anything in the constitution. Yes. As an outcome of this, they literally have the powers to change every single article in the constitution. That itself is arbitrary because it could have no reasonable bias. So, by the doctrine of basic structure, you have limited certain parts of the constitution, certain principles of the constitution rather, that the judiciary will always protect, that the parliament cannot touch via a judicial amendment. Do we understand this? So, my fundamental question to you is, the power given to the parliament under Article 368, is it an arbitrary power? It may not be an arbitrary power, but is often used arbitrarily, because they used Article 368 in a way to curtail the status of fundamental rights. They used Article 368 to add Schedule 1 to the Constitution, which curtailed the judicial review of anything under Schedule 9. Yes, through the First Amendment. As a result of which, you compromised fundamental rights. That is fairly arbitrary. So that's the first reason. That is the first reason. The relationship between arbitrariness, basic structure and rule of law is, even though the parliament now has powers under 368, they have used those powers to add the 9th schedule, to add laws to the 9th schedule, which cannot be judicially reviewed, even if those laws are violating fundamental rights, where you have Article 13 Clause 2, which clearly says no fundamental right shall be violated. Isn't that the case? Right or wrong? Yes. That is the relationship. My second relationship is, what is the relationship between doctrine of basic structure and predominance of legal spirit? See, you have to be very precise with your arguments. You have seen the kind of questions they have been asked in the mains. Unless the second you get onto this romantic, poetic end, judiciary, judicial review, that is where you have lost the interest of the examiner. I need you to be very precise. Tell me the relationship. Go ahead. Bilkul. Yes. बताओ. What are the components of predominance of legal spirit? ये तो बता दो. This is theme number 1. Yes. What are the components? बोलो. Okay. What is the most basic component of the predominance of legal spirit? 2 things. If there is a right, there must be a remedy, and there must be an enforcement mechanism for those rights. And an enforcement mechanism for those rights is nothing but judicial review. Now tell me the relationship between the doctrine of basic structure and judicial review. Does it help judicial review? Does it not help? Does it advance the cause? How does it advance the cause? And so on and so forth. Yes. Okay, what else? Very good, excellent. What else? Okay. The answer to judicial review is a multi-layered answer. The first part, using the doctrine of basic structure, you have eventually held judicial review to itself be a part of the doctrine of basic structure. Eventually. That means any legislative act, any constitutional amendment which effectively takes away your ability to judicial review can itself be declared unconstitutional because of the doctrine of basic structure. Yes, that's number one. The second argument to this would be, through the doctrine of basic structure, you have used its powers to bring almost every element of the Constitution under judicial review. Think about the Yr Coelho case of 2006 reported in 2007. You have been able to do this because of basic structure. The final judgment of Yr Coelho says what? Doesn't matter what is in the 9th schedule. Doesn't matter when it was put in the 9th schedule. If it is violating basic structure, then I have the right to review it. It opens all possible parts of the Constitution, yes, to judicial review, right? Third, because basic structure is more about principles than provisions, it allows the courts to get into domains that it ordinarily would have not. For example, you would be referring to the judicial accountability problems. For example, you would be referring to the National Judicial Appointments Commission. You've been able to challenge laws. You've been able to challenge socio-legal issues because of the larger idea that they are principle-based, not provision-based. Yes. And these principles have an evolutionary nature. Correct? Yes. This is a good mains answer. The significance of basic structure, it is that it has solidified the two most important foundations of the Constitution of India, which is rule of law and constitutionalism, right? Then what you do is, before you get to the second part, you set up the same box that we discussed yesterday. You put the doctrine of basic structure in the middle, and you think of all perspectives of it, everything that links to or has an impact on basic structure. For example, we discussed judicial review would You would discuss how federalism would have an impact. It would be impacted by basic structure. Yes or no? And then you look at how the doctrine of basic structure could sometimes get out of hand. For example, it could open the floodgates of judicial activism. The fact that it still is not in any document whatsoever, but we follow the same diagrammatic approach, the primary issue of basic structure. So constitutionalism, rule of law, judicial review, and federalism. All of those are the 4 core keystones of judicial review. Do we understand this? Good. So this answers my primary question, which is, what is the significance of it? What has it effectively done? So what would now my concluding statement be? Think about it. What could my concluding statement be? No, for significance, yes. Okay. Through the doctrine of basic structure, you are trying to uphold principles of what? The Constitution. Through this, you are coming an inch closer to constitutional supremacy. This does not mean we are a constitutional supremacy. It simply means we are closer to constitutional supremacy by upholding principles of the Constitution. Understood? Fine. Now, the impact that we were discussing. What has the basic structure doctrine effectively led to? Okay, how? The abstract ideas should always come a little later. You should start with how precisely has it helped. Okay, and how do you protect fundamental rights? Go ahead. Okay, how? Yes, the first and the most solid impact of the doctrine of judicial review is that it has solidified, concretized the idea, the notion of judicial review. If 13.2 specifically spoke of, and this is a very important question, that no law can violate a fundamental right. You effectively were looking at judicial review of laws that violated fundamental rights. Because of the doctrine of basic structure, you could now look at the review of anything that violates any principle of basic structure. So you have expanded the scope of judicial review. Do we understand this? Yes? Excellent. Now, because of this, I have a very important conceptual question to ask you. The doctrine of basic structure basically says anything that violates such principles of basic structure shall therefore be declared void and unconstitutional. Is that correct? Yes. Now, anything that violates these principles, what is that anything? Okay. Does law here mean law as per Article 13(2)? Think about it very carefully. See, it's a very interesting question if you think about it. My question is, nothing can violate doctrines of basic structure. It is derived from, it's similar to, no law can violate fundamental rights under part 3, and you gave a definition of law, and you said law is everything. Law does not mean two things. Is it gone? Sorry. No law can violate fundamental rights. Law means everything except constitutional amendments under Article 368, and it does not mean emergency orders, right? What about this? What is nothing? Yes, it has. Okay. Very good. That's the problem. That's exactly where the problem is. The context to this is ordinary powers and constituent powers. I'm saying nothing can violate the doctrine of basic structure, which means a constitutional amendment under Article 368 cannot violate the doctrine of basic structure. That would be correct. Yes, that's the very obvious part of it. Yes, because the doctrine of basic structure comes from the Constitution. So any change to the Constitution that violates the doctrine of basic structure is therefore invalid. Can an ordinary law violate basic structure? Why? Why? Okay, but ordinary law cannot violate part 3. Can ordinary law violate anything else? See, ordinary law cannot violate fundamental rights. All fundamental rights are not basic structure. My question is, can an ordinary law violate the doctrine of basic structure? Why? ये लिखा किधर है? No, it includes certain ideas of fundamental rights. Agreed. The right thing to do is include it, but do you understand the legal conflict? Directive doctrine of basic structure comes from the Constitution. So any change to the Constitution which violates any such principle is wrong. And ordinary law has nothing to do with the Constitution. An ordinary law has nothing to do with the constitution. So an ordinary law has nothing to do with basic structure. That would be the right thing to say. That is why in the Madras AOR Association versus Union of India case of 2011, the Supreme Court applied the cause and effect test of Yr Coelho and said even ordinary laws will be subject to the doctrine of basic structure. Otherwise, it was not possible. Otherwise, an ordinary law cannot challenge you. They can do whatever it is that they want. Take a simple example. Forget about part 3. Parliamentary democracy is basic structure? Is a part of basic structure? This means I cannot make any change to the constitution in a way that it takes down parliamentary democracy, because parliamentary democracy is a constituent of the basic structure. Yes or no? Yes. Absolutely correct. Absolutely correct. But what if I come up with something called electoral bonds? Electoral bonds fundamentally undermine parliamentary democracy. Now, can I challenge electoral bonds because they violate basic structure? No, you can't. No, you ordinarily can't. Which is why the Supreme Court had to give a judgment. The cause and effect test. That even ordinary laws which have a cause and effect to the principles of the constitution cannot violate the doctrine of basic structure. Do we understand the minor point? Yes. Okay. Yes, absolutely. But it was not so now. The law is as good as it is written. The doctrine of basic structure is applied to constituent power, by logic should apply to ordinary power. By logic, the parliament should not have the power to erase the constitution. But you had to come up with 70 years of jurisprudence for it. Because when you say that the principles of the constitution cannot be violated, who violates the principles of the constitution? Constitutional amendments. And ordinary law has nothing to do with the constitution. Superior, inferior, it is a separate law. So the doctrine of basic structure should not apply to any other law apart from the constitution. Which is why you had to increase its domain. So the fact of the matter is, even ordinary laws cannot violate the doctrine of basic structure. They cannot. You can, but my point is, it is still outside the purview of a constitution. The parliament has the powers to make a parliamentary law because of the constitution. So just because of that, does that mean that the law has to necessarily abide by the doctrine of basic structure? No. It is obvious, it is logical, but it is not necessary. You have to be very precise in the application of law. Because think about it, if ordinary laws could not violate basic structure, that is only when you could question the Sabrimala judgment saying secularism is basic structure. Because an ordinary temple management law was prohibiting women of a menstrual age to not enter the temple. Do we understand this? Are we clear on this? Yes? Exactly. This is what my point of reference is. This is what my point of contestation is. In fact, if you actually read some of the bare acts, especially the yellow ones, this AOR Madras case 2011 is actually mentioned in the footnotes, that the basic structure doctrine will also apply to ordinary laws made by the parliament, which could have otherwise not been the case. Do we understand this now? Yes? अगर कोर्ट उसको आइडेंटिफाई करे तब बिल्कुल that is the point of argument. Supreme Court has declared parliamentary democracy to be basic structure. The essence of parliamentary democracy means transparency of elections, informed voting, unbiased government. Yes, and electoral bonds could question the basic tenets of parliamentary democracy. So could you question electoral bonds as violative of basic structure because parliamentary democracy is basic structure? Yes. But for that there has to be a law. You have only extended it till ordinary law. Electoral bonds is not a law. Understood? Sabrimala was backed by a law, an ordinary law. Electoral bonds was not backed by a law. Are we clear? Very good. So the first impact, we are discussing the doctrine of basic structure. We figured out the significance. We figured out the significance with respect to constitutionalism and rule of law. We are now looking at the impact, and the first impact is on judicial review. Do we have our points now? Yes? How? So can we say post the doctrine of basic structure, the instances of judicial review would have increased? That's the analysis. Yes? Understood? Give a few examples. Njak, Sabrimala. It is only through post the doctrine of basic structure. Now think about it from a counter point of view. If you didn't have the doctrine of basic structure, could you have challenged the National Judicial Appointments Commission? Could you have challenged that election constitutional amendment where the Prime Minister's election is immune from judicial review? You perhaps could have not. How would you? If the basic structure doctrine did not exist, NJAC would have been a reality today. The elections of the president, the vice president, and the prime minister would be immune from judicial review. They have nothing to do with fundamental rights. You can create exceptions. This is a reasonable exception, or could be argued to be so. If you can have a diplomatic immunity, you can have an immunity towards an electoral process. Yes or no? So your arguments on judicial review are multifold. One, their instances have increased. Two, it also allows you to review constitutional amendments as well as ordinary law as violative of judicial review, as violative of basic structure. And third, it gives more depth because judicial review per se is not mentioned anywhere. Judicial review is a derived power in the Constitution. There's not a single provision in the Constitution that says judicial review. Do we understand it? Yes? Are we clear? Good. That is what we are trying to refer to. Okay? Excellent. Now, apart from this, we have used the doctrine of basic structure for federalism, the four corners. Yes or no? Any case in federalism where the doctrine of basic structure could be applied? आर्ग्यूमेंट एग्जाम्पल, आर्ग्यूमेंट एग्जाम्पल। 130 चाहिए आप लोगों से मुझे जीएस पेपर 2 में, मैं जान ले लूंगा नहीं तो। यस, it's not a federal issue. Look at the, yes, so look at the perspectives of federalism. You would have center state relations, administrative relations, legislative relations, financial relations, emergency relations. You will have issues of cooperative federalism. You will have issues of competitive federalism. And you will have special cases. Special cases would include, for example, Delhi. For example, water. Yes. For example, J&K. Yes or no? And these center state relations at a larger level are coordinated by the president and the governor. You will fall short of examples. You will fall short of space to write examples. For example, from S.R. Bommai, which we will discuss in governor and emergency later, to the most recent example of the Supreme Court saying the recommendations of the GST Council are not binding on the states. You have upheld some amount of federalism? Yes or no? To say highlighting the role of the governor. Yes? Federalism and basic structure. The fact that the Delhi judgment happened, the Supreme Court trying to uphold, then of course what we did by passing the the law is a slightly different problem, but the Supreme Court tried their bit. Do we understand this? So federalism. What else? Look at the most basic things. So, yes, coming to that. So basically, how instances of judicial review have increased. How has the Supreme Court, through basic structure, tried to better understand or change the discourse on federalism? You have tried to uphold principles of, say, state autonomy. Supreme Court judgments have largely been in the favor of state autonomy, whether it is Delhi or GST Council. They have always been in the favor of state autonomy. Pondicherry, Delhi and GST all have been in the favor of state autonomy, because federalism is basic structure. Unitary federalism is not basic structure. Do we understand it? Good. It is through the doctrine of basic structure that the Supreme Court has tried to keep a check on mild unitary tendencies by upholding state autonomy in federalism. Yes or no? Excellent. Now coming to separation of powers, which is my next point. This is very exciting. So with separation of powers, when you say separation of powers, you automatically link it to checks and balances. You automatically link it to checks and balances. Now, therefore, the fundamental question arises very simply. Supreme Court, basic structure, separation of powers and checks and balances. What is the correlation? With examples. 2 examples are more than enough. Yes, one of course is NJAC. So, what has the Supreme Court used the doctrine of basic structure to or for as far as checks and balances is concerned? It has used the doctrine for judicial independence. Yes or no? Independent and integrated judiciary, at least independence of judiciary, like judicial review, is a component of the doctrine of basic structure. Yes? So anything which has hampered that form of independence of judiciary is something that the Supreme Court has looked into. There are 2 things. One of course is NJAC and the second is tribunals. Because tribunals have judges, half of whom who are from the judiciary, half of them are from the executive. Very good. So the judiciary says that tribunals are performing a judicial function, so therefore we have the right to govern them. The executive says we have created them, we are funding them, half of the tribunal judges are ex-bureaucrats, so we should be handling them. So autonomy, control and management of tribunals has been a separation of powers, checks and balances issue, where the judiciary has always held back and said this takes away independence of judiciary. And the parliament has often made legislative changes. The deadliest one was the Finance Act of 2021. So what basically happens amongst this tribunal was, in 2021, through the Finance Act of 21, which is a part of the budget, they shut down half the tribunals in India, including the film tribunal that we've discussed in the online classes. जब ट्राइब्यूनल बचेगा ही नहीं तो लड़ोगे किस बात पे कि मेरे को नहीं खेलना है. I have the powers to shut down a tribunal, so I have shut down the tribunal. Do we understand this? Yes. Apart from this, the Supreme Court has also linked checks and balances and separation of powers to the larger issue of ordinances. Yes. Limiting the powers, limiting the repromulgation of ordinances. Yes. And lastly, point number 4. Fundamental rights. This is the easiest. By identifying provisions such as secularism, such as equality, such as liberty, you have upheld so many rights-based issues. Have you not? Yes. Sabrimala, right to privacy, right to food, all of those. So then your concluding statement becomes, and this is the interesting part, then your concluding statement becomes, the doctrine of basic structure is a turning point in the constitutional development of this country. It has changed the way the Supreme Court has intervened in legislative and executive action. It has given a more sound basis to the essential features of the Constitution by simply limiting the powers of the Parliament to amend the Constitution. Understood? Now imagine this to be the Mains answer. In exactly this way. Your introduction would be bang on, surgical strike. Through the doctrine of basic structure, the Supreme Court limited the powers of the Parliament, conceptualized a set of principles to be called the doctrine of basic structure, which would effectively solidify judicial review. The impact of basic structure is as follows. Heading 1, heading 2, heading 3, heading 4. Explain example, explain example. Concluding statement, it changes the future of constitutional development and history of the country. मेरे को मार्क्स चाहिए. मेंस में ये पूछते हैं. ये किसी किताब में नहीं मिलता, ये किसी एडिटोरियल में नहीं मिलता, और यही पूछ रहे हैं. यस और नो? बस. Now do we understand this? So, and it's not as if the UPSCs always asked very positive questions on directive principles. It has sometimes asked very obvious questions also. For example, the very first question that they asked on basic structure was, the Supreme Court has curtailed the powers of the Parliament to amend the Constitution. Critically discuss. That is through the basic structure. So then you would have to answer some basic questions. So now I'm coming to the critical analysis of basic structure. What does it mean? What has it led to? Did we really need it? Is it all good? The last part. Okay? The outcome of it. So, when we discuss the outcome of the doctrine of basic structure, what is it that we are actually referring to? Anybody would want to give some idea? जस्टिस तो ठीक है, और क्या मिलता है? ठीक है. Let me ask you a simpler question. Let's start from the beginning. Did we need it? And why? Did we need it? And why? That's my primary question. Yes. Okay. Did we need it? How would India be different if we didn't have it? How would it make any difference to your lives? Okay. Okay. You could effectively become a presidential form of government. You could effectively change the nature and form of everything if it wasn't for basic structure. Fair enough. The answer to did we need it has two parts to it. Did we need it then, and do we need it now? And then the answer to both of these questions are two very different things. Did you need it then versus do you need it now? The answer to both of these questions are specifically very different. So in 1973, why did you need the doctrine of basic structure? So 3-4 things were happening. One, in the hurry to implement socialism, we were compromising individual rights. And socialism is nothing but excessive state action or presence in a sector. That's number one. Number two, in this process, we were diminishing the status of the judiciary. And number three, we were somewhere compromising fundamental rights and doing things undignified to it. Correct? Yes? Simple enough? Excellent. So those reasons at that time would have necessitated the fact that we would have required judicial basic structure. My question now is, what about now? What about now? Do we still need it now? Or now more than ever? It's a good question. Think about it. You may have needed it then, but do you need it now? Tell me. Baba, apne saath thoda, I will ask very specific questions so that you don't have to face the pain in the mains. Yeah. Okay, good. Basically, majoritarianism is a threat. That's what you are saying. That's what you are saying. Same. That's exactly what I'm coming to. You're right. The answer to, go ahead. Exactly. Bilkul, bilkul. The answer to why you need basic structure is, if you can think of any danger to India, is the answer to that danger is basic structure. If you think majoritarianism is a problem, if you think communalism is a problem, if you think any rights issue is a problem, the answer to all of it is basic structure. This is a shortcut. Pick up all the isms that you think of, add whatever you want to before the ism. The solution to that ism from a legal point of view is the doctrine of basic structure. The solution to capitalism, socialism, communism, chauvinism, regionalism, casteism, sexism is basic structure. It would eventually come down to a rights issue. Fascism, majoritarianism, communism, communalism, the answer to every ism is effectively basic structure. That's a simple shortcut to this. You don't have to memorize it. There is nothing fancy about it. Which then brings me to the larger discussion. Is it necessarily good? Does it necessarily help? Have we done more good than bad? Or have we done enough damage? To understand this, let's go back to where we come from. Are we constitutionalist first and democratic later? Or are we democratic first and constitutionalist later? The answer to this question is the answer to the question, is basic structure good or not? Because the answer to basic structure is a basic conflict between constitutionalism and democracy. It effectively is this. And it is one of your syllabus's most beautiful ethical conflicts, if you think about it. You can be a constitutionalist and not a democratic. Because what is so constitutionalist about basic structure? We've answered. We've answered its significance when it comes to constitutionalism. Have we not? Yes or no? Okay. Now, what is so undemocratic about basic structure? While, and this is why you could write this in your mains answers also. While declaring parliamentary democracy to be basic structure, the fact that you're able to do this is undemocratic. An undemocratic institution is declaring parliamentary democracy to be a basic structure without any bias, without any basis. Think about it. There are multiple issues in terms of the objectivity of basic structure. The first and foremost effectively is the length, the vastness, the depth of the judgment. Now, where is the problem with the volume? When we say our first issue is with the volume, what is actually the problem with the volume? When we say that this judgment effectively runs into 800 plus pages, runs into 4 lakh words, etc., 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 right? What does that mean? These 4 lakh words across 800 pages are signifying what exactly? They're signifying the opinion of 13 Supreme Court judges. That itself is a problem. Let's first figure out why. Because none of these 13 judges are elected. All of these judges are appointed judges, and even worse, self-appointed judges. They may have saved the constitution, they may have saved the country, agreed. But did you have the right to? All of these 13 judges are self-appointed judges, internally appointed judges. Number 2, you are looking at a very narrow margin of 7:6. Within these 13 judges also, you've not been able to build consensus. If 13 people in this country cannot agree that there should be basic structure, it effectively came down to a factor of 1. If there was a 1 split, then this entire discussion would have not happened. This discourse over the last 2 days would have not happened. A, you are undemocratically chosen. A, you are self-appointed. B, you aren't even unanimous. And the interesting part is, as you would have seen yesterday in the timeline, most of these constitutional cases have been by a factor of 1. Most of these constitutional cases have always been by a factor of 1. 3:2, 4:5, 6:5, 7:6. Shankari, Sajjan, Golak, Keshu. If the judiciary cannot come up with the degree of unity, for the lack of a better word, for something as crucial as basic structure, which is going to alter the very democratic fabric of this country, I fail to understand how is it even just to celebrate basic structure. That's the first problem with volume. The fact that it is not unanimous enough. The second problem with volume, as we understand it to be, is the too much information problem. is effectively the too much information problem. With these 4 lakh words across 800 pages, 13 judgments, 13 separate opinions. Out of these 13 judges, there were at least 11 separate opinions that I can recall. 11 judges have written their own versions. There are 13 judges, the judgment ratio is 7:6. So 7 have agreed on something, 6 have not agreed on something. That something is, yes, there should be doctrine of basic structure. And there are 13 judges who have out of the 13 judges, there are 11 judges. There would be a dissenting opinion, there would be a supportive dissenting opinion, and then there would be majority opinion. Every judge would have written, at least 5-6 judges have written a majority opinion, which is why every judge has given their own list of basic structure. Which is why you will never find any reliable textbook saying, according to Kesavananda Bharati, basic structure means this. Because it cannot. They have referred to some items here or there, but it is one judge writing an opinion. It is the only judgment that I can recall which has an official summary released with it. And it is on record that a few of the 13 judges did not even agree to sign that summary. Did not even agree to authenticate that summary. So what happens, the second problem with volume is that you are effectively lost in what is called translation. You are effectively lost in translation. And that is not necessarily a good thing. Do we understand this? Yes? Excellent. Third, the second issue apart from volume is the relevance and the coherence of it all. Because there is still no clarity and there are academic debates, it is like reading a religious textbook. Everybody can have their own interpretation of what the judge has written. And the problem is not the fact that it is just lengthy, it is also written in a very, very complicated manner. And because it is written in such a complicated manner, it is always going to have those kind of issues. Are we clear on this? No doubt. This judgment has had a great impact. Bangladeshi Supreme Court, a couple of Kenyan, South African Supreme Courts, they have given a reference to this. They have adopted it. Bangladesh in a constitutional crisis, the Supreme Court of the Bangladesh used the basic structure doctrine, sort of referenced it to us. How we've referenced US and UK cases on several tests, the Hicklin test and so on and so forth. Our Supreme Court test has also been referenced by the Bangladesh Supreme Court. The Bangladesh Supreme Court, while giving one of their constitutional judgments, has referred to Kesavananda Bharati. That's a very good thing. But my point is, take a step back. What is the doctrine of basic structure effectively about? It is about the theory of implied limitation. That you want to have a limitation on the amending power of the Constitution for rule of law, for constitutionalism. Now that limitation has to be implied. It cannot be explicit. It cannot be explicit because if it is written down in a piece of provision, it could be erased off. That's the doctrine of basic structure does not exist anywhere in any law. It's not in any parliamentary law, it's not in the constitution, it's not anywhere. It is a set of principles consistently evolved by the Supreme Court through their judgments. But it comes down to the theory of implied limitation. Limitation on the powers of the parliament to amend the constitution. Now think about why would you want to do this? All of us have studied 368. We've all seen this figure 2/3. This 2/3 figure comes from where? It's a midpoint between the American Constitution and the Australian Constitution. To amend the American Constitution, you require a 3/4 state ratification. To amend the Australian Constitution, you require a referendum. So we look at 2/3 as a reasonable number. The most recent constitution at that time was the Irish Constitution. And the Irish Constitution was a Catholic constitution. And they also had certain immunities. They had certain limitations on the parliament with respect to the constitution for X number of years, and then extended by an X number of years. For the first 10 years, the parliament cannot touch the constitution, and then maybe extended for another 10 years. And the German constitution, the Weimar constitution, had the concept of it. And Nani Palkiwala, in the Golak Nath case, when he was assisting, had just name dropped the idea of basic structure. The concept of basic structure is not a judicial invention. It is an argument made by the great Nani Palkiwala, which was adopted by the court and then given a lot of structure. This is the reality of basic structure. Do we understand this? So what is your way forward? Your way forward is very simple. Basic structure is about constitutionalism. As long as you're trying to protect, promote and safeguard constitutionalism, either from parliamentary action or inaction or judicial action or inaction, you are sorted. Because you are right. If a military rule is bad, so is a judicial rule. If military dictatorship is a problem, so is a judicial dictatorship. If Indians think of judiciary as the knight in shining armor, that's not necessarily healthy. You cannot think of an appointed institution as your knight in shining armor. It has to effectively be the democracy. Do we understand this? Yes. So this is your closure. अब उनको मेंस में जो पूछना है पूछने दो. अपने पास सबका जवाब है. क्यों किया, इससे क्या होता है, मतलब क्यों किया, इसका क्या मीनिंग था, इससे क्या होता है, सही किया, गलत किया और आगे क्या करना चाहिए. The way to end basic structure is extra constitutional means. This is a very important question. How do you remove basic structure? One, have a higher bench, which is unlikely. You will require 13 bench or more, 13 judges or more. Two, either through referendum, which is constitutionally not provided for, or you replace the entire constitution by installing a new constituent assembly, which is hypothetically dreamy, or you have a revolution in the country. And this is not me saying it. This is D.D. Basu in the actual textbook, the Fat 2 volumes. He's the only author who refers this. That basic structure can only be changed through revolution, referendum, or refreshing the constituent assembly or changing the constitution. That answers your other means question also. And all of these are unlikely. The idea is the only way that you can overrule basic structure is through extra constitutional means. And the fact of the matter is, the basic structure doctrine has done more good than it could have done harm. And as long as that is the case, constitutionalism is protected. So your answers in the mains exam would be pro basic structure as long as constitutionalism is upheld. Bas. This is your official opinion. Understood? Are we clear on this? Excellent. So with this we finish basic structure part 2. Okay? We can study for a little longer today. I hope that's okay with you. Can we take a quick 5 minutes break and then we'll start with the next lecture? Okay. We now start with theme number 3 or topic number 5, which is directive principles and fundamental duties. Now, from an exam point of view, this is slightly more important for the prelims than the mains. Before the new pattern was introduced, there was one question on the utility of fundamental duties about 15 years ago. But in the last 10 years, in the mains, there has been absolutely no question whatsoever from directive principles or fundamental duties since 2013, ever since the pattern has changed, ever since we have GS paper 2. But we should generally be prepared. Now, as far as the prelims is concerned, we have already covered the kind of questions that are asked in the prelims in our earlier discussions on a comparative overview. Now, what are the kind of questions that come? And this is highly likely: identification between a fundamental duty and a directive principle. They'll generally give you a statement and they'll say which of the following is a duty, which of the following is a directive principle. And we have figured out a 2-layered test for this. If you as the citizen are implementing it, it is a fundamental duty. And if the government is implementing it, it is a directive principle. And if you read the text of the statement, if it is informal, if it is personal, if it has some behavioral qualities, some adjectives of that teacher, then it is a fundamental duty. Whereas if the usage of the terms is formal, then it is a directive principle. So that's the first part. Second, you get a larger question on the purpose of fundamental duties and directive principles. So directive principles are largely for socio-economic democracy. Fundamental duties have no obligations whatsoever in terms of their legal status, right? The third question that we generally get are obligations / legal status. Now there is a slight minor difference. In the prelims, the answer is very clear. Directive principles or fundamental duties are not enforceable in a court of law. This means if the government is violating a directive principle, you cannot take them to court. Similarly, if a citizen is violating a fundamental duty, you cannot take the citizen to court. But can they be implemented through legislative or executive action? The answer is a yes. They very easily can be. You can make tens of laws and tens of schemes on the basis of fundamental duties as well as directive principles. It is not a restriction on legislative power of any kind. It doesn't say you can't do this or you can do this just because it says so, right? And fourthly, rarely so, you may get a question on classification. Now, classification is generally applicable only and only to directive principles, where Gandhian, intellectual and socialist. We've also figured out a trick for it. If it is about something grassroots or about something orthodox, it is Gandhian. If it is speaking to you about something which has to do with equal distribution of resources or equality of opportunity, it is socialist. If it's not either of the two, it is then liberal / intellectual. We've covered this as far as the pre is concerned. Now comes the mains exam. For the mains exam, you will never be asked complicated questions from here, but for both of these things in the mains exam, you simply need to have whatever you have studied for the pre in a long form for the mains. So which means for the mains exam, for directive principles, you need to know their purpose / their objectives. Second, as we had identified, their obligations or their legal status. Third, what are the additions / subtractions that can be made? And fourth, what is the larger role that they play in a given country? For the mains, this is more than enough. And this is a highly example driven answer. So for example, if you're talking about how have directive principles being implemented, pick any 4 and give real-time examples of those 4. For example, you could say MG Narega is an implementation, right to education is an implementation, free legal aid is an implementation, speedy trial is an implementation. All of those are implementations of directive principles. What I would generally suggest is, I'll give this to you in your notes also, I will give a status implementation chart with each directive principle. What are the laws that we have made? What are the schemes that we have made? Has the judiciary also done something around it? Because if you think about it very uniquely, the fact that the right to a speedy trial is a fundamental right, the fact that legal justice is a fundamental right, or legal aid is a fundamental right, it's because the judiciary has interpreted it in a way. It's because the judiciary has said that, you know what, legal aid is a fundamental right, but legal aid was in directive principles. So therefore, you have upheld a directive principle to actually be a fundamental right. If you think about it, you have upgraded the status of a directive principle to also a fundamental right. For example, right to education is a classic example. Originally, 6 to 14 years was in directive principles. You upheld right to education to be a fundamental right, and 21A was added. So 21A had 6 to 14. Now DPSP also had 6 to 14. 21A also had 6 to 14. Now fundamental rights are compulsory. DPSPs are not. You can't have the same thing compulsory and non-compulsory. So they changed directive principles from 6 to 14 to 0 to 6 for exactly this reason. So there are some unique cases. For the prelims exam, though I don't think it should be asked, but just in case, keep a separate box of additions that were made to directive principles. The changes, the new directive principles versus the old. There could be a question that could be, which of the following were added later? An unlikely question, but nonetheless. Okay? So let us now first begin with directive principles. Let's understand this and let's take it forward. Okay. The first things first is, what is the concept of directive principles of state policy? What is the larger idea behind it? What are you trying to do with this? How does it really make any difference? Anybody? Why would you even have something like this? Go ahead. For a welfare state, okay. Do you really need it for a welfare state? Can you not do it without DPSP? Would we not be a welfare state without directive principles? Yes. Okay, very good. Fair enough. What else? In the prelims, they had asked you a question: which of the following is fundamental to governance of a country? And the answer to that question was directive principles, rightly so. So, directive principles at the outset are supposed to be two indicators of two things: one, welfare, and two, governance. It isn't just about making society and the lives of people better at large. It is also figuring out the best possible way to execute those solutions. So, directive principles, philosophically, idealistically, are going to serve two purposes: welfare and governance. And they are indication points. Now, the brief point of analysis is directive principles of state policy in the Indian constitution, our constitutional scheme, have a very ambiguous position. They have a very unique position. If you read part 4, and the difference is part 4a has been added and part 4 has been a part of the original text, which means it has always been the intent of the makers of the constitution to always have directive principles. You've done the comparative scheme. We know we've taken it from Ireland, they've taken it from Spain. We know all of that in the earlier lectures. But in this lecture on an analysis, if you read directive principles, they are generally framed as a set of guidelines. Yes? However, they are framed as a set of obligations without making them enforceable. It is perhaps the only unenforceable set of obligations on the state. Aren't they written as obligations on the state? They are. They're written as proper obligations on the state. But the constitutional text very clearly renders them to be unenforceable. Right? Now, even if you look at the history behind directive principles, the members of the Constituent Assembly were also fairly divided over the nature, the positioning, or whether you should even have directive principles in the constitution also. Because, rightfully so, a lot of people did not find any utility of it. If you can't take the government to court, if they are not under an obligation to implement it, it is as good as doing something on a fancy basis, on a whims basis. Why are you creating an unnecessary text in the constitution, elongating it, creating more scope of judicial confusion, leading to judicial intervention? Why are you unnecessarily complicating the dish? There's absolutely no need for you to do so. And there was a large section. While the others, very large chunk of people, had also argued that why don't you put directive principles under part 3? You've anyways written them as obligations. You can keep it as you've kept Article 15 and 16. Article 15(3) says you can make special provisions for women and children. Nowhere does it say now. Nowhere does it say within 10 years. Even if you read the additions that have been made to Article 15 and 16, whether it is 15.5, 6, 16.4, 4A, any of those, none of them say that you have to implement a reservation policy today. They have been worded in a way that nothing is going to stop you if you decide to make a reservation policy. Nothing is going to prevent you from making special provisions. Nowhere does 15 and 16 say you have to. Nowhere does it say that you need to at this very moment. In a way, you could have written directive principles like that. You could have created an obligation within Part 3 and therefore kept an open-ended timeline for the government to implement it, right? And at the same time, there was a fair degree of contradiction within directive principles, because in one end, on the one hand, you've got abstract economic principles like prevention of concentration of wealth, distribution of resources. On the other hand, you have very concrete policies, very, very specific policies, like prohibition of liquor, or say controlling, cow slaughter. Directive principles as an entire unit in itself is extremely diverse. You have a set of goals, you have some aspirations, you have some unenforceable rights also. It has goals, it has policies, it has rights. And this concoction of articles that we've created under directive principles therefore becomes very interesting as a piece of legislation. Do we understand this? Yes? Good. And despite the drama that happened in the Constituent Assembly, we still eventually ended up having Part 4. But even after that, life has anything been but straightforward. The sheer amount of judicial sort of principles or the judicial approach to DPSPs as a whole, individually, and their relationship with fundamental rights. These are the three things. The judiciary looking at DPSP as a whole, the judiciary looking at DPSPs specifically as DPSPs, and the relationship between DPSPs and rights. The judicial approaches have largely been inconsistent, as we've seen through Champakam, Kerala Higher Education, Kesavananda, and effectively Minerva Mills. So, directive principles, though unenforceable, have created such a judicial discourse, have gone into so much depth, that it is now almost an unnecessary evil. You have to deal with it because you have to deal with it. Are we clear on this? Yes? Okay. So, this begins with my first and foremost question, which is the need for directive principles, the purpose for it. The answer to this is a very simple one. The answer is you needed to have socio-economic welfare / democracy in the country, and it is a tool of guiding for principles of governance. That's it. Nothing else is absolutely needed. The larger question is, have directive principles fulfilled their purpose? Have they been of any use to us? The answer to that is yes. Almost every directive principle in some manner, form, shape has seen legislative action or executive action or something that the judiciary has spoken about. Something as simple as that. Something as simple as land reforms. Something as original as, say, nationalization policies. Every nationalization policy effectively is an issue of directive principles. Yes or no? Every socialistic policy is an issue of directive principles. If you look at something very specific, equal pay for equal work, you've tried to have labor codes now, trying to bridge gender gap. When you have directive principles on strength of workers, management of industries, worker participations, you have better labor codes on industrial participation, legalization of trade unions. All of these are implementation charts. Through free equal justice and free legal aid, you have effectively converted a directive principle into a fundamental right. The 73rd and the 74th Amendment and PISA are implementations of organization of village panchayats. The right to work is today the largest food for work program in the world through MG Narega. Yes or no? So all that I have to do very simply, is to just pick up my directive principles and see where all, on what all have we effectively implemented them as. Nothing else, just look at how we've implemented them. If you simply start from one end, state to secure a social order for the promotion, and can you all see this? State to secure a social order and promotion of welfare of the people. This is nothing but every socialist policy that we can think of. Land reforms and, let us say, nationalization. The exact same thing is applicable in 39. Certain principles of policy to be followed by the state. Citizens, men and women, equally have a right to adequate means of livelihood. Think of every livelihood program that you can. From MG Narega to Deen Dayal Upadhyay Livelihood Mission, these are all implementation mechanisms. Simple. Every National Urban Livelihood Mission, National Rural Livelihood Mission, now it has been combined into one centralized mission. It is nothing but livelihood. Ownership and control of material resources, which is basically prevention of concentration of resources, is again socialism and nationalization. The same applies for 3, concentration of wealth. With concentration of wealth, think about the examples. Nationalization of banks, Jandhan, yes, Aadhaar, financial inclusion, ONDC. Every financial inclusion policy is effectively 39C. This is how you make your answers richer. This is how you add a lot of perspective. Think of a law, think of a scheme, equal pay for equal for both men and women through our industrial codes, through our labor codes. And then health and strength of workers is again industrial codes and our labor codes. Factories Act, today you have a code for industrial safety, code for social security, trade unions are constitutionally recognized. Then equal justice for free legal aid, as I was telling you, is a DPSP recognized as a fundamental right, as rare as it could be. Yes or no? Then we've discussed about 73rd, 74th PISA for village panchayats. This is MG Narega, the right to work. Right to education and to public assistance in certain cases is, for example, this plus this is legal aid, NALSA, public services, integrated child development schemes, National Social Assistance Program, NSAP. Yes, right here. To provision for just and human conditions of work and maternity relief. You have the Maternity Relief Act. You have the Matru Vandana Yojana to provide for better conditions for pregnant and lactating mothers. Living wage, you have a code on wages today. A minimum, and you have labor commissioners, labor courts, labor acts, commissions on Safai Karamcharis. All of this is Article 43. Trade unions, participation of union workers. All of this comes in your new labor codes. Promotion of cooperative societies, which was added much later to the 97th Amendment 2011. There was a recent Supreme Court judgment also that it's a federalism issue where state governments will have full autonomy over state cooperatives and central government can give directions over national cooperatives or interstate cooperatives or multi-state cooperatives. So you have a proper cooperatives policy. Today we have a new ministry on Ministry of Cooperatives. How more could you have implemented it? Then Uniform Civil Code, which is through multiple law commission reports. There is Goa which does it. Some form of activity is there for almost everything. Early childhood care and education, your national education policy specifically has an element on early childhood care and education. It has, the previous version of it is now a fundamental right. Promotion of educational and economic interests of scheduled caste tribes and other weaker sections. 15, 16, 14. Your essential 14 to 18 is this. You have 5th schedule, 6th schedule. You have Article 371A onwards. Autonomous councils in certain regions. You have a Ministry for Tribal Affairs. All nutrition schemes come under 47. Poshan Yojana, Shishu Poshan Yojana. Everything comes under Article 47. Every possible 2 or 3 major agricultural flagship schemes. Your National Irrigation Mission, your National Dairy Mission, Horticulture Mission is agriculture and animal husbandry. To have an Environmental Protection Act, this is after we signed the Stockholm Convention, we finally realized we need to have a dedicated environmental policy. Remember, we've done environmental rights. It was the Stockholm Convention which was a changing point for us. It is after that and the Bhopal gas tragedy that we finally had dedicated provisions on environment. The Supreme Court has given you multiple interpretations on the environment. Yes or no? Yes. Significantly so. And if you just keep scrolling a little bit below, you will see your your Archaeological Survey of India. Incredible India as a campaign. Yes. Separation of judiciary from the executive was done through an amendment to the earlier CRPC, trying to be, implemented through and through, and as much as possible. In very rare cases do US district magistrates get to hold courts, or SDMs get to hold courts. And every foreign policy, such as non-alignment, Panchsheel, is effectively promotion of international peace and security. So just have a table. Now it works in both ways. All the issues that I have discussed, in reverse you can, if there is a question on hunger, if there's a question on living wages, on unemployment, you could say the directive principles give us an obligation to do so. If it is a question on how far have we implemented directive principles, do the reverse and you have an answer here. It works both ways. If you're writing an answer to environmental protection, you could say directive principles Article 48A encourage us to protect the environment. It works both ways. You'll be able to prepare both ends. Answers on implementation of directive principles and answer on those specific implementations, the context to be directive principles. Works equally well on both sides. Do we understand this? Yes or no? Fair enough. So this is the larger purpose. This is the larger implementation status, nothing else. For the prelims, you should know that there are two classifications. Either directive principles are goals, policies, or rights, or they are Gandhian, socialist, or liberal and intellectual? Goals, policies, rights, Gandhian, socialist or liberal slash intellectual. Do we understand this? Yes? Bas. And each of these cases I'll give you like a bunch of Supreme Court judgments also. Like just and human conditions of work, I'll give you the judgment of the Bandha Mukti Morcha case, where the Supreme Court has referred to DPSPs. Slum dwellers case. Are we okay with this? Yes? Excellent. Now, apart from all of this, the final question is on the justiciability of the charter. What is effectively the role of directive principles? Can you take the government to court for violating directive principles? No, not at all. Not at all. But if the government wants, can they implement directive principles through a law, through a policy, through an action? Yes. This is in one simple line, the justiciability of directive principles. And it is very categorically given in Article 37. It shall not be enforceable by the court. And the prelims will never ask you random questions. That is why I keep telling you, read a few things in the Constitution. Read a few things which are necessary. Read Article 37 for me just once. You'll get your prelims question here. The provisions contained in this part shall not be enforceable by any court, but the principles therein laid down are nevertheless fundamental to. The prelims will never ask you an abstract question. It has to be within the text. कुछ चीजें वर्बैटम पढ़नी है तो पढ़नी है. ये लाइन से था. Fundamental to governance. सोचना ही नहीं. Because our first trick of the prelims exam is, if the question says as per the constitution, so it has to be explicitly in the constitution. We can have a 5-hour discussion on how fundamental rights are fundamental to governance, and you will convince me and I will convince you that yes they are. Article 37 में क्या लिखा है? Fundamental to governance. प्री में मार्क्स उधर से आएगा, प्री निकलेगा तो मेंस लिखेंगे. Always remember. समझ में आया? Yes. Very good. Now, as far as fundamental duties are concerned, ठीक है? ये सारी, इसमें दो चार इम्प्लीमेंटेशन देखना है. जैसे नेशनल फ्लैग कोड हो गया, जैसे प्रिवेंशन ऑफ इंसल्ट्स टू नेशनल ऑनर्स एक्ट हो गया, टू रिस्पेक्ट द नेशनल एंथम इट्स मेंबर्स. बट माय प्राइमरी क्वेश्चन टू यू इज, व्हाई डू यू हैव फंडामेंटल ड्यूटीज? ये बहुत इंपॉर्टेंट क्वेश्चन है, बिकॉज यू मे गेट दिस इन जीएस पेपर 2. दिस इज अ ब्यूटिफुल एथिकल डिलेमा. सब एथिकल क्वेश्चंस का आंसर यही होता है. Duty more than right. Don't ask what the country can do for you, ask what you can do for the country. बस इसका जवाब fundamental duty. And it all goes back कर्तव्य. Yes, कर्तव्य. Mahatma Gandhi said, the true source of right is duty. If you discharge your duties, rights will never be far to seek. ये means में चिपका के आना है. एग्जामिनर का आंख में आंसू आना चाहिए. क्या लिखा है? Do we understand this? Yes or no? Yes. See, all said and done, fundamental duties were never a part of the original text of the Constitution. They were added through the 42nd Amendment of 1976, which is why they are called Part 4A. The question is, why were they added in 1976? They were added in 1976 based on the recommendations of the Swaran Singh Committee report of 1976. This is the official recommendation. But why does this happen? This is very important. Because when you are entering the era of excessive socialism, hyper socialism, with the advent of emergency, you have to call upon people and say, we are doing our job, you bloody well do your job. You be good citizens, we will take care of you. Here is a list of duties that you have to follow. In fact, you'd be very, very interested to know, none of the Western countries have something to do with fundamental duties. You will see fundamental duties mostly in socialist constitutions. And none of the Western constitutions are socialist. So none of the Western countries have fundamental duties. The relationship with fundamental duties is also with socialism. That's the idea that I'm trying to tell you. Whether it is directive principles or fundamental duties, what joins them both is the spirit of socialism. So what is the relationship between socialism and fundamental duties? That's the basic question. The relationship between fundamental duties and socialism is that while the government takes care of everything, you have a responsibility to be a good citizen for the government to take care of you. It's not a precondition, but it is a good expectation. Are we clear on this? Yes. So that's the general idea. Which then brings me to a larger question. Why have you not enacted fundamental duties as in the original text? What happened? Why did you wait for the 1970s, right? First, they did not, the framers of the Indian Constitution at that time didn't particularly feel the need to enact it. Now, why would you not feel the need to enact it? First and foremost, they said, we are such visionaries. We have such a good understanding of life. We understand Indians are going to value their freedom. They will understand that we have fought so hard for our freedom. We have bled to death for our freedom. So they will be responsible citizens anyways. These are basic values that have to be practiced by everyone. I don't have to spell it out to you. It is too obvious to be true. That's the first and the foremost reason. Two, if you think about it, in some form, these fundamental duties are also spelt out in the preamble. When we talk about fraternity, when we talk about equality, freedom of liberty of thought, it's not just about what the state gives you, it's also about how you give this to each other. So there is definitely some resemblance of fundamental duties within the preamble itself, right? And third, the rights that we have inherently have a degree of obligation. For example, 15(1), non-discrimination in a public space applies to hotels, restaurants and public resorts as well. Do they not? Then they absolutely do. And because that is the case, it would effectively lead to rights to also mean duties. Do we understand this? Yes? Are we clear? But this is why you did not have fundamental duties as such in the Constitution. We figured out the need and the importance of it. We also know that the enforceability of fundamental duties is as good as directive principles. Can you? Yes. Do you necessarily have to implement them? No. And if a citizen violates them, do you have to, can you take a citizen to court just on the basis of the violation of fundamental duty? The answer is no. And we've had several legal provisions implementing fundamental duties. We've had, for example, the Prevention of Insults to National Honors Act. We've had the Flag Code. We've had provisions in the Protection of Civil Rights Act, which replaced the Untouchability Act. We've had the Forest Rights Act. We've had Prevention of Cruelty to Animals Act. We've had RTE, right? Now that is the interesting part. The 86th constitutional amendment is the only constitutional amendment which singularly changes a right, a duty, and a DPSP together. It inserts 21A, it changes DPSP from 6 to 14 to 0 to 6, and it adds a brand new fundamental right that says provide opportunities for education. The 86th constitutional amendment is the only fundamental right which actually does so. Are we clear on this? Yes. So there are obviously some drawbacks. A, they are very vague. B, they're extremely, they are categorically non-justiciable. 3, they have been inserted after part 4, and that gives you a sense of hierarchy. Rights, DPSPs, and duties, they come last. And 4th, it is never very clear that a violation of fundamental duty, will that lead to any constitutional repercussion? Understood? Having said that, the role of the judiciary here has also been very, very restrictive. We've discussed the Ames versus Ames case, reservation within reservation. In that case also, Supreme Court said fundamental duties are not enforceable through a writ, very categorically. There have been also cases with respect to environment. The case was Rural Litigation Entitlement Kendra versus UP. I'll give it to you in your notes, where the Supreme Court clearly said we are issuing directions to the state under Article 51AG that environment has to be protected. The Supreme Court has time and again issued directions to the state under fundamental duties, despite the fact that they are not enforceable. So in the mains, you enter a little bit of a gray area. Things become a little more complicated, right? Similarly, in MC Mehta's case, the environment case, the Supreme Court literally gave a set of guidelines with respect to environmental education, that all educational institutions should at least have a weekly class on environment, get environmental textbooks, have short courses for teachers, and not only central government but state and local government should also do this. All of this was, it is the duty of the citizens to have compassion for living creatures, to protect the environment. How will the citizens be able to do their duty if they don't know about the environment? So, direction to the state to make environmental curriculum so that people can follow their fundamental duties better. Do we understand this? Yes or no? Yes. And finally, the National Commission to review the working of the Constitution, right? That in itself has given some glad and very glorious recommendations. वो बोलते हैं कि duty to vote, duty to respect religions, duty to pay taxes, duty to have a spirit of, to respect a spirit of family values. ये सब चुपचाप रट के एग्जाम में उल्टी करके आना है, ठीक है, अगर आ गया तो, और अपने मन से 2-4 ड्यूटी भी चिपका देना, नो प्रॉब्लम एट ऑल, जो अच्छा लगे. बोल देना एनसीआरसी ने बोला है, नो प्रॉब्लम, क्लियर। दिस इज व्हाट इज फंडामेंटल ड्यूटीज, इसके ऊपर नहीं आएगा। अभी क्लियर, गुड। अब आपका इज्जत और मेरा इज्जत अब आपके हाथ में, ठीक है। किताब कॉपी बंद करो, बंद करो।